Hi students, I welcome all of you all to the JIGL marathon. Let me tell you the plan for today. I will first be taking you through the chapter wise weightage of JIGL. This has been taken through a series of parts that we've seen the chapter wise weightage, and it's applicable even for your examination. Okay, now the very first one, this is the updated list as per ICSI as on date in 2025-2026. Okay, so from December 2025, this is the weightage, and this weightage I have accurately calculated. Where you do the total comparison, it will come dot 100. Okay, so we will be going in order. First, we go to see the important chapters. One is your Constitution of India. It has the highest weightage. Then if you go to see your 3 criminal laws which are there, so they are asked for around 12 marks. So you have 24 marks. Then you have your sources of law, and then Arbitration Conciliation Act and your Contract Act. And Contract Act, mostly the questions will be situational based. Now if you go to see all the other chapters which are there, they will be asked for approximately 5 marks. What we will do for today's plan, I have shown you the chapter wise weightage. You want, you can take a screenshot of it also. You know the key important chapters, that is the main purpose of it. Okay. And civil procedure code, rest all the other chapters comes for around 5 marks. Now second, on our website we have also kept the scanners which you can download. It's a past exam questions with model answers as per ICSI, which I'm going to refer it today as well. Okay, so we'll come to know which are the questions that they have asked in the last attempt, that is June 2025. Each one we will be seeing, and then we will knock off each chapter. Okay, now marathon will go around for 3.5 hours. Okay, and in the process of this marathon will be conducted for 3 days, today, tomorrow and day after, and that I'll cover a substantial part of your syllabus. Okay, now we'll begin with the first chapter, that is sources of law. You can keep your books open from whichever notes you have studied, keep that open. Your module, if you have a classes book, your own notes, you can use that. Clear till here? Okay, cool. So again, if you want to attend, you can attend face to face as well. Okay, and online on our YouTube channel. Good. So before I start, can I have a GTG in the chat box? And before I start, one more thing I want to tell you before the marathon starts, that in this subject, okay, I had, something which you all are aiming for. I have already achieved it, and I will tell you the plan behind it. Okay, so all of you all are giving executive, and you all want to clear executive in one attempt. Yes or no? So with God's grace, I have done that. Okay, so cleared in one attempt. So it's a dream for the students, and I will tell you my trick, my entire strategy to you. Second, not only that, now as we are having the marathon for JIGL, wouldn't you want an exemption in JIGL? Exemption is how many marks? 60 plus marks. Okay, so I had also got an exemption in JIGL way about 60 marks. I was close to 70 marks. Okay, so this gives me, and I've been teaching the CS course for over 10-12 years. Okay, and now I will tell you the trick that I have used for getting the exemption. You all want to know that? Okay, everyone, because preparation is a little weak. You get scared for your examination, such a vast syllabus, the language is so technical. How do you get that exemption? So let me tell you. The first thing that I did was I told myself repeatedly that I'm going to get an exemption. Before I even went to the exam hall, I knew that the paper will come easy. I knew that I know everything, and I know the correction will be easy, and I knew I'm going to get an exemption. Clear? So before we start, the foundation is you need to have that fire in you, that madness that I want to clear with amazing marks. So before we start, wherever your books are there, notes are there, write the word exemption so that your brain is programmed to get a exemption, and then you will be studying from a topper point of view and you will get that as well. So just can I have exemption in the chat box and exemption wherever you're there, you can write it down to keep yourself motivated. That's your target. Clear? Everyone, exemption in the chat box. Great, 60 plus everyone's writing. Cool. Chalo. Now we'll start with the marathon. The first sub chapter that we are going to do, we will time ourselves as well. I plan to complete it in 1 hour's time, less than 1 hour, this entire chapter. Sources of law. It's a 6 to 8 marker chapter. Okay, and that's an average. So they might ask you more or less as well. So this is a exam oriented marathon. So I will be telling you everything which is important from exam point of view. What is not important, I might go a bit, I might skip those parts as well, but mostly the chapter will be covered beautifully. So now let's begin. Hi, so we'll be starting with the chapter called as Sources of Law. In Sources of Law, I'm going to leak out the entire paper for you. In Sources of Law, questions can come only from these three brackets, no other place. What is that? First is, what are the legal theories? Okay, first they ask you the meaning of law. In meaning of law, you will see natural school of thought, analytical school of thought, all the different schools of thought are there. 5 to 6 schools have been given. So you need to, this table you make it so that you can write all those things where it is, you know it or not. So we'll be doing it in the process. Then the second and the most important part also is your sources of law. In sources of law, what are they telling them? From where this particular law has been made. Okay, what are the sources of making laws for the legislators? How did the law was being formed in the world, in India, anywhere? And third, there are various jurists. When I say jurist means what? Those who are legal experts. They have given 6 legal theories. You will see 6 names, 6 big names. HLA Hart, okay, Jeremy Bentham, and all those 6 names you will see. You need to know their theories because that comes in the exam. Okay, let's begin. Now this is the introduction. Now in introduction, how do they start off the particular chapter of sources of law? What is sources of law? First I have to understand what do you mean by the term law. Okay, and then I'll try to understand that how was law made. So sources of law means from where law was made, and definition of the term. Okay, what do you mean and define by the term law? So first, now you all have studied this chapter, it's a revision lecture, so you must be knowing what is law. According to you, what is law? If in examination they ask you, what you will tell? Put in the chat box. I'm going to teach you, ask questions, and when you will answer, you will come to know what you missed out. So what do you think? What do you mean by law? Very good. So the common answers that everyone will give is the rules and regulation, right? But I'll tell you what I expected from a student of law, or I should say a expert of law. Can you see this? In your entire, anywhere you go, the definition of law is not given except for in the Constitution of India. So you have to write this. If they ask you anything related to law, you write it, nobody else will give you. That as per Article 3, Sub-Article 3, what is the meaning of the term law? So we know rules, regulations, etc. That is a general understanding. So this we need to quote. What we will write? Law includes. This is constitutional meaning of the term law. It means law includes. So they have given an inclusive definition. Sir, what do you mean by the term inclusive? They have not told what does law mean, like how you all are telling rules, regulations. They are telling what all is covered under law. So everything, ordinance, order, bylaws, rules, regulations, notifications, customs, okay, having in the force uh, in, in force in India. Okay, so any rules, regulations, ordinance, bylaws, etc., which is in force in India is called as law. So this is what I want you to write. Okay, now when you go up, how do they start off again? They say that there is no universal definition of law. As many jurists are there, that many definitions are there. Sir, what do you mean by the term jurist? Jurist means experts of law. So if you bring 10 experts of law, they'll give you 10 different definitions. What we need to know specifically is the Constitution Article 13(3), which gives a inclusive definition. That's all that I want you all to know from exam point of view, and a few names that you can remember. Few legal experts you can quote apart from my name. Okay, so you will see Alpane, the pain to remember his name. Stereo seems like a name of a car, and Justian Digest. Okay, so any few definitions. Now again, remember, students are wondering why they don't get exemption, because they are not quoting. Basics everyone will write, quoting very few will do. So take a definition whichever you like from your, quote it in your exams. Okay, and don't write the meaning definition of law. See what are they writing? Definition by jurist. What do you mean by the jurist? Means expert of law. Okay, now simple things. What do you mean by law? It is arts and science of what is good. It tells us what is just and unjust. It's a standard of what is just and unjust, and the highest reason implanted by law. So any one of the definitions, they'll never ask you the definitions proactively from your, but you can quote it proactively. So any one definition, whichever you like, I expect you to learn it, and the part of your law is done. Okay, now significance of law. What do you mean by the term significance? What do you mean by the term significance according to you? Significance, you all can put in the chat box. Importance of law, why it is important. So we can say that a law, what is the significance of law? First, we can say that because of law, there will be a social order. It is a what? There will be a social order. So law is a tool for social order. So these keywords, key sentences, I expect you all to write when they ask you. Second, they also tell you that why law is important. Let's take for example any one, let's say section 135 of Companies Act. Can you all tell me what it is regarding? 135 of Companies Act. Make a guess. So there was about corporate social responsibility, CSR. Okay, that the society, that the companies have to give something to the society. Now the thing is that okay, now the thing is that this law, was it there before the in Companies Act 1956 about CSR? Answer is no. So what happened, that time they never considered that companies should work for the benefit of society. They never mandated anything. But in today's time, if you go to see with the global scenario, people expecting that they should be doing, they should help out the society. So the law changed. So is law universal and static? No. So again, law is needed according to the changing times, because world changes, business environment changes. That is why law needs to be updated from time to time to meet the prevalent norms aspirations of the people. Again, if we go to see, first they were never talking about AQI. What was AQI? Air quality index, right? But now, due to the changing environment, global warming, people getting more aware, they are talking, and we may have a law, and companies may have to follow some more stringent laws than what are there today. Okay. So again, what is the significance of law? World changes, so law has to change to meet the aspirations of the people. To meet the aspirations. Aspirations mean the expectations of the people around. Now, relevance of law to the society. How is law important? Again, not, we've discussed this already. I have told you it is a tool for social order. This you can write. Now coming to the term jurisprudence. So we have understood the meaning of the term law. From here, 2-3 things we need to know: a definition, section, which is section. What is the section number? 13, sub article 3. Perfect. Now coming to the next thing is jurisprudence and jurist, definitions given by jurist. Now this entire subject, what is the name of your subject? JIGL, that is jurisprudence, interpretation and general laws. So you need to know what is the meaning of the term jurisprudence. If you get an opportunity, you would definitely quote. So jurisprudence is divided into juris, and the other one is called as prudence, and the other one is prudence. Okay, what does juris means? Law, and prudence means knowledge. So juris means law and prudence means knowledge. So what is jurisprudence? Is this knowledge of law. Collectively you could say this is the knowledge of law. Simple. So a person or an expert in law, a person who is an expert in law will be called as a jurist, right? So this basic definition of jurist we require, and then you will see a few big names will come, and those names come in your examinations as well. Okay, so before we get into that theories of Jeremy Bentham, can you tell me any names? Jeremy Bentham, then Professor Hart, then you have John Austin, etc. Right, in your modules it is there, and these are direct 5-mark questions that have been asked repeatedly in the exam. So out of these 6 jurists, 1 normally comes in the exam. Okay, so let's see. I'll give you techniques of learning that aspect as well. Okay, first, legal theory. Just before we start, 2 things they want to know: positivistic and normative. Now you must have read, when you were studying this entire subject or this chapter, you must have heard of positivistic and analytical and normative theory. So what is that? Let's understand that nicely first. Legal theories are divided into 2 categories. Again, sir, what? Legal theories, pay attention. Legal theories are divided into positive legal theory and normative legal theory. Which is the other one? Normative. In economics also we had done, when we were in 12th, positive and normative science, whether economics is a positive science or a normative science. In the end they say it is both. So what was positive science? Explaining things as they are, not passing any moral judgments. For example, if they have said that what is the age for alcohol in India? Which one? Very good. So nowadays generation know this very nicely. So after 21 they know what they can do. Okay. So if you go to see, simply telling that this is the law, this is the date it was passed, and this is the entire judgment copy which is there. Okay. That is called as positive legal theory. Positive legal theory. They study the law, what it is, why it is like that, and how it affects the society. That's it. They don't pass moral judgments. When they don't, it is a positive legal theory. Okay, they just study the law as it is. Normative legal studies tell you what should or what ought to be. Okay, what should be? It shows, it passes a moral judgment. You tell me, is 21, should alcohol be allowed at any age? No. So very good. So you're passing a moral judgment. What are you doing? You're passing a moral judgment. If you do that, you pass moral judgment that you should not be there, it's not good. You're telling what ought to be or ought not to be, what should and should not be. So that would come under the normative legal theory. So is this clear? If I say a positive, so legal theories are divided into how many categories? Two: positive and normative. Positive studies things as they are, okay, as it is, and normative, what ought to be, what ought not to be. Okay, so they pass moral judgment. Simple. So when you will see that XYZ is the positivistic theory propagator, means he used to propagate positivistic theory. So don't get confused. Just remember, you don't have to remember, but now you don't have to get confused with it. That this is what he want. He explained things that law should just tell this is the law. They should not go into moral judgment. Some say no, moral judgment should always be considered, right? Now coming to the legal experts who are there, and now for each legal expert, I want you to write it down in front of your name of the author with the keywords that I will tell you. So in the exam, when it comes, you don't have to think, you can start writing. Okay, the first one that we will be studying is Jeremy Bentham. So the first one we are studying is Jeremy Bentham. Okay, 8 aspects. Now again, in the exam they have asked, tell the legal theory propounded given by Jeremy Bentham. So where you have to write the name Jeremy Bentham and the keyword, you have to remember 8 different aspects. So what is 8 different aspects? I will tell you. In his entire theory, he talks about this 8 different aspects which really helps you build a theory. So now let's get back. And some facts you need to learn about them also. Some facts you need to learn. For example, Jeremy Bentham, okay, was, and most of them you see are from UK, Britain, because Indian laws are all derived from UK. So he was a pioneer expert jurist in Britain. Analytical jurisprudence. What do you mean by analytical? Logical. They will analyze 2-3 things and then pass their judgment. Okay. So first thing is, Jeremy Bentham is the pioneer of analytical jurisprudence. 1. He, now just the start, if you write it well in high level language, it just feels good. Then you write that he defined law. According to Jeremy Bentham, what was law? He said, very simple, there is a sovereign, and if you don't follow the sovereign, you will get a sanction. Similar to what others said, but his key focus area was the 8 points. Now pay attention to what I'm saying. Jeremy Bentham was the pioneer of analytical jurisprudence in Britain. He said that law is an assemblage of signs of declarative of the volition, that is your intention of the sovereign. Simple words I'll explain. If you want, you can write it, or you can write it in simple words also. That according to Jeremy Bentham, who was a pioneer in analytical jurisprudence, law was an assemblage, an assembly, okay, of what? Assembly of the will of the sovereign. That will, English language, what they've said? Volition. Volition means what? Intention of the sovereign. So obviously it's so simple that the supreme person, like the government, makes the law, directing how the person subject to its authority must behave. So they will direct how the others should behave. Okay. Law is a command of sovereign backed by the sanction. So again, what we'll write, that Jeremy Bentham, pioneer of analytical jurisprudence, said that law is an assemblage, assembly, okay, combination, collection of the will, that is will, another language is volition of the sovereign directing how the subject should behave. And if you don't behave properly, you will get a sanction. Sir, what do you mean by sanction? Sanction is a punishment. Simple. Then, so that is a key word. You have to remember that written, analytical jurisprudence, and then you have to learn his definition, which is also very simple, sovereign and sanction. Then he talks about pain and pleasure. What did he talks about? Pain and pleasure. That human being learns from two ways. You will follow a law only for two things: pain or pleasure. Anyone human react on basis of either pain. For example, if I tell you that if you do not pay your taxes, you will be in jail. So going in jail is a pain. So that will make you to pay taxes. Pleasure could be that if you do this registration formality, if you do this, the house will be in your name. So the pain and pleasure is there. So people will act, are motivated to act. So you write it. According to him, he believes human beings are governed by two forces. They are motivated by two forces. One is pain and pleasure. Okay. Either they want to gain pleasure or they want to avoid the pain. You want to become rich, so you will work, right? So that is, in order to gain pleasure, you will work. Or if you don't want to become poor, then you will avoid pain. Okay. Now, sir, you were telling about 8 aspects, right? Again and again, I was telling about 8 things. This is what it is, the 8 aspects, okay, about law. What is he telling? 8 aspects about law. Now, let's understand the 8 aspects of law, what it is. Okay. Now, first thing is 8 aspects of law. If you go to learn, it will not happen. I'll tell you how you have to think. First, if I tell you that define law, what a law should cover. So you will say, see, listen, the law should tell from where it is coming, the source. They should tell, the source means the sovereign, who is the supreme command, who is passing the law. Then on whom he is passing, that also you should know. So you should know that to whom the law is being subject to, whether it is applied to human beings, to women, to any XYZ, to whom it is being applied, who are the subjects, who are the sovereign, source and the subject. Third, every law has been passed with some object, so you need to know what is the purpose or the goal. Right now I'm just quickly reading through, then in the end I'll ask you how many you can remember. Then comes, is every law applied to all over the world? No. Then we need to know the extent of the law, whether it is a state law, whether it is a law made in the village, or it is an international law. The extent of the law should be identified. Then comes the aspects. Now again, if I go to see that laws also can be divided into procedural laws, and we could say the descriptive laws. So 2 essential parts of the aspects. What are they telling you in aspects? One, they are saying that what are the rules that you have to do and follow, and the other one, if you don't follow, what is the sanction? Always write the word sanction means punishment. So I'm just thinking, they are telling who passed the law, on whom they have passed, where all it is applicable, okay, and what if I don't do? So you get a punishment, a force. A law may give you force or may give you an option also. Can you tell me any place where law gives you an option, not a force? Wearing a helmet is a force or an option? You can choose not to wear a helmet while driving, but then they get penalty, na? So whenever you don't follow, then you will get a sanction. So that is a force that you have to wear a helmet. But also you see right to marry. It's an option you might not have to do, or right to vote. It's a complete option. Nobody will have any penalty. Okay. Now if harm is there, then what remedy is provided under the law, compensation, etc. And last part is expression. A law is ultimately an expression of the sovereign will, and its meaning must be understood from the terms and legal language used to express that will. So you have to, the expression will be contained in the act, right? So now, last time we just go through it. The expression will be contained in the act, remedies will be given. Sometimes laws have a sanctioning, a compelling power, aspects, extent, object, subject, and source. How many you can remember? So in Jeremy Bentham, what is the main thing? We have to remember the 8 aspects. So source, from where it is coming, then subject, on whom it is to be done, then object of the law, and the extent. So this is the important part. Then next, the aspect. Now in aspect, what do they cover? That this is how you have to do, like this is how you have to pay the taxes. If you don't do properly, you get penalty. Obviously, then the connected with that is force. Remedial. So there will be a remedial, and the last one is expression. So the expression of the government or the supreme body is contained in the act or in the law itself. Clear? Then again, he, in order to elaborate your answer further, he has also said that how law can be complete. Okay, again, 2 things you will write. According to him, law will be complete. Completeness of law will be in 2 cases: unity and integrality, or you could say completeness. Now what does it mean? You can write these 2 words. Law will be complete if integrality and unity is there. Means if a law covers all the possible situation of that subject matter, it is said to be complete. Means all the aspects of law should be covered. Okay, then it is complete. And in unity, what do they say? That it should have one topic in one act. For example, Companies Act relates to what? Only companies. Income Tax Act relates only to income tax. So again, that is a unity of the subject, One subject should be there in one act, and it should be complete in all aspects. So the expression should be clear. Design should cover all the situations that is there. If they have failed to do, then they will call that it is an incomplete law. Right? Simple logic. And now we have to start criticizing him. Okay, now we start with the criticism. How will you criticize him? I'm just thinking, if I have to criticize this guy who's selling 8 aspects, etc. Okay, now did he, first, always we can say it is rigid, it is unrealistic. Okay, he's saying it is always a command based. He's saying that there will be whenever someone says that there are supreme authority who is making the law, but in international law that is never there. In international law there is no supreme body who can order anybody. WHO is only a guiding source. UN is also a guiding source. Nobody can force you to do anything. Second, he has said that laws are always made by the authority, but he never said that customs are also there which authorities don't make. They themselves follow how to get married, etc. is not any law government. Instead, the other way around. The kings and the authorities go back to the custom to find out the law. Then you can say that they have never given recognition to the judge-made law. Why? Because what did he say? That the authority will make the law, but today courts are also making laws. If you read the Visakhapatnam versus state of Rajasthan, the Supreme Court made a law for women safety. So even judge-made laws are there. Obviously, authorities can make the law, but even judge-made laws should be. Okay. With this, we have completed one. And pain and pleasure is subjective. So if he's saying pain and pleasure, but it is subjective from person to person. For some people, money might look like a burden. Money would be like, it is a big issue. Where do I do? It is causing anxiety. So though it should be a matter of pleasure, but it could also be matter of pain. So what is happiness to someone differs from person to person. So simple word, pleasure is subjective. 100 people like skydiving, maybe some people don't like. So pleasure is subjective, happiness is not guaranteed. Okay, so again he had said one thing, that state should try to do greatest happiness of greatest number, but even in spite of giving people everything, they might still not be happy. So happiness is also not guaranteed, or it is also subjective when he's saying that state should give unlimited happiness or greatest happiness of greatest number. Okay. Now we go to the next one. Next one is John Austin. Now what did John Austin say? Now they were positivistic theory of law. Sir, what do you mean by positivistic theory? Do they pass moral judgments? No. Okay. So now we have John Austin, which is very simple to what we read above. But the above what we had read was, you write about command and command and sanction, but 8 aspects also you write. This guy's entire theory, Austin's entire theory is around that there will be a supreme command, and if you don't follow that command, you will get a sanction. Okay, so first thing is there will be a command, they will give you a duty to perform, and if you don't do, there will be a sanction. Sir, what do you mean by sanction? Again, I told you it is a very simple, it means a punishment. Kelsen, on the other way around, what did he say that about grand norm, which we will come first? Let's finish John Austin. So again, John Austin, very simple, very easy. They have asked in the exam also. Okay, which is about. So in John Austin, again, I know how to write the command theory of law, but I need some background about him. What does he do, etc. In case if I don't remember anything, at least write that he is a jurist. And also if you go to see, everyone will be from UK or London. It's the same thing. So he has studied from, he was the first occupant of the chair of jurisprudence at University of London. His theory is called as command theory of law. Now let's see what is there, the definition of his theory. Definition of the features of law. So again, according to Austin, law is a command of the sovereign backed by the sanction. This line you have to mandatorily quote, because this is his entire definition. That law, what do you mean by law? So he is saying law is a command. Command by whom? By the sovereign. And if you don't follow it, it will be backed by a sanction or a punishment. So command, sovereign and sanction. We can easily explain what is the meaning of the term command. So command is basically the will of the supreme, and that if that will is not followed, you will have evil consequences. Evil consequences, the correct legal term is what? Sanction. It means sanction. See, sanction means a evil consequence, and sovereign means there is a person who is independent, like a king or a government, and they are passing the law. Now you have to sit and criticize Austin theory also. So I'm just thinking, Austin theory, again, as I told you, this will always be there. In international law, there is no sovereign. So again, international law is not covered only because there is no sovereign authority only. Okay. Second, if you go to see, again, none of, obviously all the jurists have forgotten about judge-made laws. So you will say that they have not covered judge-made laws at all. They've always said that there is a supreme commander, he is passing a law, but today's courts are also there, and they also pass laws and make laws. Okay. Then sovereign authority limited. Okay. So according to Austin, the sovereign does not have to obey anyone. But in today's time, does the government also has to follow the courts, has to follow the constitution? So that is incorrect to say that the sovereign is really sovereign. Supreme is so supreme that nobody is not answerable to anyone. So that is a criticism also, that the sovereign authority is limited, is not unlimited powers. And then comes welfare legislation not covered. Most modern welfare states pass, see again, what did he say? That always they are passing commands only. But today if you go to see, they are also welfare states. They are not only giving commands, they are also giving you rights, powers. That is not covered. So simple criticism is there and it is done. Okay. The next that we'll be coming to is Kelsen's theory. Okay, Kelsen's pure theory of law. When you're doing Kelsen's theory, you have to remember Grund norm. What do you have to remember? Grund norm. Okay, Grund norm. So all this, I am hoping you're writing the name of the author, what is the key name of his theory, and some background about him. And then the most important is criticism, etc. Okay, and the keywords. So now again, pure theory of law. What did he say? Very simple. He said that, again, now this guy is the first one who's an Austrian guy, philosopher from Europe. He's a jurist whose theory is called as pure theory of law. Very simple law, but directly go, you'll say, oh, it's so simple. Okay, they are just saying that all the laws are called as laws, norms. All the laws are called as norms, and there is one mother of all norms that is called as Grund norm. In India, which is the Grund norm? Constitution of India. Okay. Like laws of normative science. According to him, law is a normative science. The laws are what ought to be distinct from what is prescribed. So let's come to the main part. See. First is all norms derive their powers from the ultimate Grund norm. Okay. The Grund norm, according to Kelsen, law is primary norm. A norm is a sanction that is forbidding or prescribing a certain behavior. So what did I tell you? A norm means a law. And what does a law do? Either it forbids you or prescribes something for you to do. Pay the taxes or don't murder anybody. That's a norm. All the norms, or the highest possible norm, is the Grund norm. So you have to remember that Kelsen, moment you see the word Kelsen, you should remember pure theory of pure theory of law, and you should remember the Grund norm. And automatically you will do build with constitution, etc. You can make the pyramid also, that the Grund norm is the supreme and everything else is below that. Grund norm doesn't derive the power from anyone because it is the mother of all norms. Okay. Now, in India, the Grund norm is all the other authorities are deriving their powers from the constitution. Now we have to sit and criticize Kelsen also. How will we criticize Kelsen? Let's understand. First, we say it is very difficult for every law to find a Grund norm. In India, we know, but in China, so they might not be followed by a book which is having all the laws. So there is no yardstick to tell that this is the Grund norm, this is not. One, there is no time frame for effectiveness. How long a Grund norm should be effective to be called as a? There is no timeline given that this law, if it is followed for so much time, can be called as mother of all laws. First of all, it's difficult to identify. Second, is not given also that how long it should be there. How do you determine which is superior? And when any time you go to analyze the Grund norm, the pure becomes impure, because you cannot go and check so according to him, this is the main book. From the main book, all the other laws are made. You can never go to analyze the Grund norm. If you do that, the theory becomes impure. So obviously we do amend constitution also. We do recheck so many parts of constitution. So that is also a limitation. International inconsistency. In international law, there is no concept of Grund norm altogether. Okay, so we've criticized this guy also. Now we are going to John William Salmond. Okay, now for Salmond, the key word you have to remember for Salmond, John William Salmond, what is the key word given for him? Is law and administration of justice. So what will you remember? That law as an administration of justice of John William Salmond. Now all the first two authors, from where they were? Location UK. Then above author Kelsen was from Austrian guy. And these guys come from a much more beautiful place, that is New Zealand. You can just remember it, just before the exam you just check and then take their names and go, because one normally comes. Okay, so William Salmond is, you know, a professor in New Zealand. Okay, and he has made a seminal, that is a massive contribution in jurisprudence, law of torts, contract law, a lot in New Zealand, and he was also a ex-judge of the Supreme Court of New Zealand. Okay, and he spoke about one thing. According to him, what was law? Law is a means of delivering justice. Write this down. What is law? Law is a means of delivering justice. So, according to him, law is a means of delivering justice. Okay. Now, definition of law. Definition of law. Law is the body of principles recognized and applied by the state in administration of justice. So again, you will see the word justice, justice, justice in different phases it will come. Okay. So you will see here again, what do you mean by law? Law is a body of principles that help you give justice. Again, law is a set of rules that courts act to give justice. Similarly, you will go. Okay. A reference is to give justice, so it's all surrounding the keyword, that is justice. Now, further, let's see. Salmond says that, now again, justice is something. Can you give me another word for justice? Justice, another word for justice. Give me another word for justice. So justice basically means fairness, but fairness differs from person to person. So who will tell that this is just, this is unjust? The government. So Salmond experienced that human experiences shows that some form of compulsion is needed for maintaining justice. You need to give some compulsion. Conflicts arise between individuals and society, and people cannot be left to decide what is solely right according to their judgment. Right? You cannot leave it on the people only to decide what is right and what is wrong. There has to be some compulsion, because I want to play, it's my birthday, and after 12 I want to play the loudspeaker. So individual rights and society rights can be a conflict. So I feel I am right, they feel they are right. So obviously there has to be some compulsion from the government. Okay. So administration of justice is important. Okay. Now let's criticize him. Now they are saying justice can always not be delivered through law. Means, can there be laws which are unjust ever? Depends. If a corrupt politician and government is in place, they will try to kill the opposition by making unjust laws. So laws can be unjust too. Okay. Laws have purpose beyond justice. It's not how justice is when something is wrong is happening, we're trying to give you justice. But higher standard of living, growth, you know, your different aspects of human aspiration, that is also important to achieve. Contradiction regarding universality of justice. Very difficult to find a universal concept of justice. Okay, whether veg food one can have or non-veg is a universal debate going on for years and in all parts of the world. So it's a universal justice can never be achieved. Then comes of Rossio Pound. Now let's look at Rossio Pound. What does he say? Now Rossio Pound, remember the key word, that is theory of social engineering. So you will again remember the word social engineering. Now what do you mean by social engineering? According to him, now again he's an American scholar. According to him, that society, to regulate the behavior of humans, law is made. So law is made as a tool for society. We look at the social facts, we come to know that this problem is there, accordingly we will make the law. So in Canada, if you go to see, there is something called as even if someone has lost their job, they get salary from the government. They look at their society, they look what they need to do, and then accordingly they give them this kind of wages. So it's a social fact. They look at the social aspects and they will do. And what did he do? He looked at the lifestyle of lawyer and an engineer, and then he made a theory of social engineering. He said that he wants to make society. Now remember, social means society. So he wants to make a efficient society. So remember this keyword. Now, conditions for a efficient society. What all should be there in efficient society? In a efficient society, okay, interest. Now, if you go to see here, the word interest is there, and it will keep on happening. See, classification of interest, etc. Now, coming back here, keywords. Okay, so now we are looking at the keywords for this particular thing, that is society. Sociological means social or society. One. Second, you will look at making an efficient society. And to make an efficient society, as I told you one example, that I want to play the loudspeaker even after 12 o'clock. So obviously it is my individual interest versus the society interest, right? So now this keyword interest also you have to remember, because interest will be used multiple. My interest as a as a citizen of India, as a married man, as in the society, in my lifestyle, in my personal life. Okay, all those will have to be seen. So let's see. In an efficient society, it is important to balance all the interest of everyone. Now let's look. Okay, conditions of efficient society. Recognition of interest. I have to identify what all are your rights, your interests, your wants. I have to definition of the limits. I need to limit it. Securing those limits. Then once I limit it, I will try to achieve, try to get and secure to whoever the interest is there. For example, laborers should get the maternity benefits, women should get. So my job is to first figure out that these are your rights. I have to see that you get those and secure those rights. I have to say that your rights are limited to this much. You don't have unlimited rights. Okay. Now coming to the steps for determining the scope and the subject matter of law. According to Rossio Pound, the following 5 things are required to be done. Now let's understand what is it. Determining the scope and subject matter of the law. So everything is surrounding the interest. So first I have to identify what all inventory of interest, what all interest do you have. Then I will see that which all can be legally given to you, legally recognized. Then I will see that what all limitations are there. Okay, then how I will give it to you, and evolution of the valuation of this interest, means ongoing review should be done. Now coming to the interest aspect. For this we have to just take an example that there is an individual. Okay, this guy is there. This guy has a right to dress the way he wants, marry whoever he wants, yes or no? So these are all his individual rights. Okay, in individual rights, his personality, how he can, his rights with his children, from his parents, inheritance rights, and his property. So personality, domestic relations, and substance as in property. All this is there, individual interest. Then from government point of view, individual has certain property. Does the government also have any property? Yes. So government as a juristic person, as an artificial person, they also have the similar rights. Okay, and this they also have a right that they interest of the state as a guardian. So they are also act as a guardian for the country. And then comes social interest. Social interest means what? In society. In society, everything. You go, someone, you require general security. You require, security of social institutions. General morals are there, moral principles which are there. Conservation of the moral resources, general progress, individual life condition. So some of these points you can learn. Okay, generic stuff. But you have to remember individual interests, public interests, and social interests. These are the keywords. Individual means you're in as a personality, public is what the government has, and society as your behavior in the society. These interests has to be done. Now, what are the criticisms of Rossio Pound? Interest, you always feel that there is an interest and then the laws will come. Okay, however, it could be other way around. The law has created an interest for you. That also can have like a right to vote. You never had it from before. Government made a law and then they give you the thing. So reverse can also happen where it's not that the interest will first be there and then the law is then found. It's the other way around. The law can be made to give you an interest also. No criteria to determine, doubtful distinction. Okay. Now coming to the next one, HLA heart. Now HLA heart, I have just added a little more because the content in the module was very less. Let's read the initial part first. HLA heart. Now is a British. So again, there were among 3 UK legal jurists who are there, and he is a professor at the Oxford University, and he's written a book of concept of law. Okay, now let's see what does he talk about. According to Hart, law is a human creation and not dependent on any custom, anything. Again, law is a human creation. Who made the law? We made the law. So it's simple that what he's saying. It doesn't matter of just, unjust. You don't have to find anything. We make it according to whatever we want. So even if it is morally incorrect, that will be the law because the humans have made the law. You go in certain countries, there are extremely laws which are extremely harsh on women. So it's morally incorrect, but that's their country and they have made it. So it's a law is a human creation. That's what he's saying. So I guess this guy doesn't have a heart. Okay. And not law as ought to be. He's saying don't see as law what needs to be done. See as what it is. There's a difference between law what is and what ought to be. He's saying law is not what ought to be. Don't look at the moral aspects. Study it as it is. And then he has said this is what I've added. Just a simple line about his theory. Primary and secondary rules. Again, so what are the primary rules? That primary rules are the rules that regulate human behavior. Okay. They forbid certain things that you cannot do these things. And secondary rules are the rules that specify how and whom these primary rules may be created, recognized, extinguished, modified, etc. So the primary rule gives the rights, rules, regulations, do's, don'ts, etc. And the secondary rules tells how you can amend it and how you can change the primary rules. Clear? Now we are done with the first part, or we could say the second part. We finished the definition of law. We finished all the 6 jurists who are there. Now we are going to the schools of jurisprudence. This we can go faster on it because more or less whichever jurist we've read, the schools of thought might have covered it. Now coming to the each school of thought. Okay, there are 6 schools of thought. Okay, 6 rules of thought. First one is natural school of law. In the beginning, first, as we started. Okay, so if you go to see the natural school of law, natural school of law, what does it say? Law is man-made or God-made? It is natural is God-made. Okay, then analytical and positivistic, I have told you what it means. We'll see. Historical means you have to find what is the law, find the law as per the history, the past. Ethical says that look at the ethics and make the law. What is ethical? Do that, moral character. Sociological is, again, whenever I tell sociological, you can always connect it with the who we have seen read above. Okay, sociological, it is a tool for social order. And realistic, what do they say? That law is man-made. It is made by courts. Similar to what we have read above. So we can go faster on this. Natural school of law. states that law is based on justice, human, and everything. They'll write the word justice and they'll write the word God multiple times. Okay. Certain rights are inherent in human nature and exist independently of man-made. So some laws are by nature, law of nature, gravity. Okay, all those things are by nature, and in our constitution also we cover them as something. What are that called? Fundamental rights, your birth rights. That could come here. Okay. Then the people who have propounded it, the different names are there: Plato, Aristotle, Emmanuel. They have all brought it. Okay, they were believers in this theory. Now, coming to the next one, ancient theory. Now, in natural school of thought only, there are some other theory which is not subset of it, not very important, but you can just go through it. Okay, one is ancient theory. Ancient theory says that universal principles of justice and reason, all of them are under natural only, so they will all be the same. Just remember that ancient theory you can write the same. First, they believe that law is what is good and what is bad and what has been given by law, unaffected by your desires. Then they slowly add something that, listen, same in natural law only we are having subparts. Okay, so medieval theory. So medieval theory, thinkers connected natural law with divine law, and they believe that law is a part of God's model order. So what did I tell you, that whenever natural comes, you will write always God, man-made, and justice. Perfect. Okay. Then they said that, this guy classified into 4 types. Eternal law, that is, how the space and everything, they all run on their own thing. Natural law, how it is naturally done, that you naturally feel what is right and wrong. Divine law and human law. So these are all have been identified by them. Then Renaissance theory. Now again in natural law, what did they say? So all of them, just with some minor variations it is there. So you can just write the name of the theory, that's enough. Modern theory, natural rights. Okay. Immanuel Kant said that the law must reflect some reasoning, some conscience, some feeling should be there. Okay. Now coming to the analytical positivistic school of thought, we have studied above, you can write all of them. Jeremy Bentham, we've done, John Austin, HLA Hart, and Hans Kelsen. So they are the important jurists, you can write about them. Positivistic feel that your law is to be studied as it is. Okay, and John Austin, command theory, Hans Kelsen, pure theory of law. All this we have done. Now, in historical school of law, what are they saying? That law is not made; it is found in the history from customs. So history means what? Customs. So you'll just write the word customs, and ahead we'll be studying customs. You can mention that also. That law is found, not made. Customs always precede the legislation. That means first customs will come, then the legislation, culture, etc. will come. Okay. Then we saw a ethical school of law. What is ethical school of law? Again, we'll write about ethics, morals, principles, justice. So since we are defining the same thing, obviously overlapping will be done. So it's fine. Then comes sociological school of thought. We read about also about Rossio Pound, sociological. Write the keywords, done. What is it? That sociological school of law is a social institution to fulfill social needs. So I had made you write that law is a tool for social welfare. Okay, for social welfare. Is a social fact. Okay, social engineering to ensure that there is an efficient society is what we had read. Okay. Now realistic. What did realistic say? That it is judge made. It is not. It is man made. Okay. It is not written. Courts actually do it in practice. Done. Okay. Now coming to the next thing is the third part, which is the sources of law. Okay, sources of law. First, the sources of law could be divided into two categories. One is the primary sources and the other one is called as secondary sources. Now each one will be seeing, that means from where law was made. Obviously law was made from customs. Okay, we'll see what are customs, past traditions, etc. What is the essentials of a valid custom is very important, past exam question. Statutes, that is the parliament, what they have passed. Judicial precedents, that's not the parliament, that is the courts that have passed. And personal laws, your personal belief, which religion you are from, that one. Secondary is basically going beyond all this, like your justice, equity, good conscience, that if a law is silent on a particular matter, then you will apply your justice, equity and good conscience, that is basically logic, fairness will be applied. And obviously all our laws, okay, our common law is general law other than business laws. Merchant law is business laws like your contract act, sale of goods act, all of that. Principles of equity and statute, so this is all UK related, that also we have derived the powers from. So this is clear sources of law, very simple. Okay, now I'll go a bit faster where the topics are easier. Okay, now first one, coming to customs. Now what do you mean by the customs? So custom is basically a tradition, okay, or an act done again and again over a period of time for a long period of time is called as a custom. Now classification of customs, let's see. Customs, some customs are mandatory to be followed and some customs are optional. So let's see. Yeah, so let's say some customs which are without any sanction, okay, which are being followed. So let's see, customs can be divided in two categories. One is without sanction and one is with sanction. So when I see without sanction, means there's no punishment if you don't follow it. For example, you tell me this is of baby shower. If you don't do, is it any penalty by law? No. Your haldi ceremony that you do in Sangeet, again these are all cases of customs without sanction. Means what? They are non-obligatory by the law. Non-obligatory. Okay. If you do it, it's pretty good. Positive morality means it is. It's a custom. So if people do it, why? Because not law is telling them. Because it is a positive morality. In order to do something to get benefits, and in the eyes of society, you have to do it. Social pressure. Then customs having sanction. So many times all the customs have now become a part of the law. If you don't follow the law, then you have a sanction. For example, with respect to, you take your personal laws with respect to divorce, marriage, inheritance, adoption, all those are there in your religious books, but now they have been made an act. Hindu Marriage Act, okay, we have Muslim Marriage Act, all those laws are there. They all have become a part of the law, and not following them will give you sanction or punishment. Okay, mandatory, so they have a obligatory in nature, that's the keyword. Okay, it is with these customs concerned with, can be divided in two categories, legal and conventional. Now customs having sanction can be divided into legal and conventional. Now what do you mean by legal? There is an act, okay, and they are enforced by the law. Okay, for example, in if it is given in the law that the property should be divided equally between the brothers, one brother is taking more, he will go to the court and enforce it in court. Okay, now legal customs again are of two categories, local and general. Now again we see so many times laws are made, but law differs from place to place. State laws are there, like that village have their own panchayat to make a form of a law. Okay, so local customs mean that sanction and that mandation or that mandatory thing is prevalent only in a definite locality. Okay, geographical, or it could be a personal custom. This is in a local category, but Okay, now if you go to see, I'll give you an example of a local custom for the marriage of a, let's say if you ever attended a Punjabi marriage or a Sikh, they keep the sword with them, they call it as a kirpan, okay, which is that they will be the protectors. Now, this is a regional thing and they do it almost like a sanction. So it could be there. Now coming to general customs. General customs are prevalent throughout the country. Okay, I'll give you a this which is prevalent throughout the country. Now, as per Christian Marriage Act, both the boy and the girl have to say the word I do, and that too in a church. There is now, though this was a custom, but now it is mandatory that they both have to get married in a church only. And in any part of India you will have to get married in a church. So it's a general custom prevalent throughout the country, and I should say even throughout the world. Clear? Then comes conventional customs. Now conventional customs are usages like, how was it different from legal custom? Okay, now we saw that this is mandatory by let's say for example laws, you do not select whether you want the law to be applied or no, it is applies on its own. Conventional customs are basically contracts that you legally bind yourself in it and then you have to do it. So a custom that you have made, it's basically, you could say, a law is now bound because you have made an agreement with the party. Now if I have done a contract, by default there is a custom that 3 days grace period will be given when there are you have a bill of exchange made. 3 days grace period is always given from the date of maturity. Now this is the custom, you entered into an agreement and it was done. Clear? But however, it should be always reasonable and it cannot alter the law of the land. Okay. Now coming to the requisites of a valid custom, very important. Okay, very important. At least you know the headings, internal content you can write of your own. A custom will be valid and binding only if it meets the following essential conditions. So these are mandatory to be followed. Immemorial means ancient. You cannot find from the beginning of a custom. If at all you can find the beginning of a custom, it is not a good custom. Clear? Next, a custom should be certain. It should not be vague. It should be reasonable. It should be compulsorily observed. It should be according to public morality. It should be universally accepted. Everyone is, unanimity of opinion is there, everyone is agreeing to it, it is peacefully being enjoyed, and there is consistently in follow. There is no there is a clear cut rules to follow the custom. Then this custom can be treated as a law. Then it is a good custom. Now coming to the next one. So we finished the first source of law, which we did. What was the first source of law? Customs. Next source of law is judicial precedents. In judicial precedents, obviously everybody will know the concept of judicial precedent. That means a law made by the court. Law made by court. Just write it down. What is a judicial precedent? It is a law or a judgment passed by the court. In this, there are 3 important doctrines that you need to know. Can you all tell me which one it is? 3 important doctrines that you have to know. So one is, these are the laws relating to precedents. So what is a judicial precedent? A judicial precedent is a previous judgment of a court. Okay. So what do you mean by a precedent? It is a previous decision of stare decisis. Now you need to know 3 important doctrines: stare decisis, ratio decidendi, and obicter dicta. So while passing the judgment, 3 things are there: stare decisis, ratio decidendi, and obicter dicta. Can you tell me what it is? Each one, do you all know? Yes or no? I want in the chat box. Do you all know what it means? Yeah. Okay. Very good. See, one is stare decisis. Stare decisis means, just remember, staring down a person so it stops. That once a judgment is passed, it will have a binding effect in future. Finish. So it is to stand by decided cases and not to unsettle things. Like a statue. Rule is being made. This is a stare decisis that do not unsettle things. Once a judgment has been made, then similar cases should be decided in similar manner. So you can write the line, similar cases to similar judgments. Okay, don't unsettle things. Ratio decidendi. What does ratio decidendi mean? The ratio of the case, the rule in the case, the rule laid down. For example, in Ganga water purification case or in the Taj Mahal trapezium case, what did the government say? That the factories, we are applying a ratio, a rule, polluters pay principle. So whoever pollutes the environment will have to pay for it. So rule is based, the rule on which the decision has been based. And obiter dicta is all the other things which is said by the way during the entire judgment, all the arguments, what the judgments have said, everything, but which may not necessarily be formed a part of the judgment or as a rule. Okay, rule might be of 3 lines, the judgment might be of so many, the entire argument might have gone over years. So that is obiter dicta. The judicial opinion might not form a part of the judgment. So clear with this? Okay. So first, previously decided cases is judicial precedent. That the precedent means a pattern for a guiding future. Okay. Now coming to the types of precedents. Very, very, very important in the exam. They have asked multiple times. Okay. Declaratory and original precedent. What do you mean by declaratory and original precedent? Very important. Let's see. When a original rule has been made, for the first time if the rule has been made, it is called as original precedent. It brings the new law. So in Vishaka versus state of Rajasthan, the court for the first time brought in a rule for women's safety in workplaces. It was never there before. So this became a original precedent. Polluters pay principle. It's an original precedent that when the law creates and applies a new law, it is called as original precedent. Whereas declaratory precedent is applying the rule in future cases. If the court just applies the future rule being made, it is called as declaratory precedent. Clear till here? Next, persuasive. So what do you mean by persuasive precedents? Okay, what do you mean by persuasive precedents? The judges are not obliged to follow, but they will take into consideration and they will attach great weight to. So persuasive means what? Let's say if a smart, if your own colleague has informed you something, you don't have to follow it, right? It will persuade you. So persuasive means what? It will have a weight, great weight, and you will take into consideration. For example, decision given by one high court will have a persuasive effect on another high court. This you can remember. But if Supreme Court has passed a judgment, it is absolutely authoritative precedent on the high court, right? So the authoritative precedent is in which the judge must follow it whether they approve it or not. Mandatory, they have to follow. Conditional authoritative precedent means what? Okay, a conditional authoritative precedent is which, though not ordinarily binding on the court before it is cited, it is liable to be disregarded in certain conditions. The court is entitled. So for example, if a high court has passed a decision, should the high court follow it or no? If let's say High Court of Bombay High Court or Mumbai High Court has passed a judgment, can it be changed by the Bombay High Court? See, we understood one thing, that with High Court of Chennai, it is persuasive. With Supreme Court judgment, it is binding. But when on High Court itself, so it is conditional, means a higher bench can reverse it. So if the judgment was passed by one judge, this can be reversed by a two-judge bench. That's called as conditional precedent. Okay, a single bench can be changed from a divisional bench. Divisional means two judges were sitting inside. Clear? So all these three rules are also clear. Stare decisis is very, very important. Stare decisis means what? Adhere to what has been stated. Do not unsettle things. Okay, why it is being made? The purpose also to bring in certainty and uniformity. And similar cases should be decided alike, and it is a form of public policy. Next, ratio decidendi. What do you mean by ratio decidendi? The rule laid down, the principle that the court has laid down, the basis on which the judgment has been given. It is different from obicter dicta. Sir, what do you mean by obicter dicta? It is a Latin expression which means said by the way. It may or may not form a part of the judgment. It is all the judicial utterances made during the judgment and during its course. They strictly do not form a part of the judgment. Okay. So obicter dicta doesn't have that much weight as ratio decidendi, but it will have some weight just to understand what was the exchanges done in the court. Okay. Then comes judicial precedences. So Supreme Court and High Court. Very simple. Any law or judgment passed by the Supreme Court is binding on all the courts below it. That is given under Article 141. Okay, law declared by Supreme Court is binding on all courts within India which is subordinate to it. High Court. Law declared by the High Court is binding on all the courts subordinate to High Court. Logic. Okay. Now we come to the third thing, which is statutes and legislations. Very, very simple. Okay, not that important, that's why I'll go faster on it. First, you have to understand that your logic, okay, that we are seeing studying sources of law. So sources, one of the sources of law is statutes, mean the parliament must have passed, both the houses of parliament must have passed the law, and then it has come into play. So there are two kinds of law. One is juris scriptum and juris non scriptum. All the customs are written or non-written. Non-written, it is just through practice. So that will come as a customary law, is an unwritten law. Whereas all our Companies Act is a juris scriptum. Okay. Then they write that legislation could be of two types. One is the main legislation, and then the other one is the delegated legislation. So GST Act is made by the Parliament. Whenever the Parliament makes the law, it is the supreme legislation. But after that, all the circulars, amendments, rules, bylaws are made by subordinate authority, that is called as subordinate legislation. Okay, so by a subordinate authority, like maybe the GST officers or GST council. So law made by Parliament is called as supreme legislation. Law made by a subordinate body is called as delegated legislation, because government cannot make all the laws every time and amendments also. They delegate the power, they give their powers to a body. All the GST amendments are made by GST council. Then personal laws. When we see personal laws, they mentioned for Hinduism, they mentioned for Muslims. So again, personal laws are also applied. Not very important for you to learn, but you should know your religion structure. Okay, the Smritis include the 4 Vedas. Smriti are the collections of the Rishis. Now very similar to what they have given. For Muslims also it is very similar. Now see, in Hindus they've given Shruti and Smritis. For Muslims, just like Shrutis are the main laws which is there, Quran is for Muslims. The main word of God is in Quran, and the Smritis, like other collections given down by the rishis. Similarly, the Hadith is the the collections of the companions of the Prophet, and his behavior and how he acted is all given in the Hadith. So similar to this, you can remember. Then comes secondary sources of law. Now secondary sources of law, we can go fast, very simple. From UK we get, and in UK similar laws will be there about all the things that we read now. Similarly in UK also all those things we can get. And one important thing that you should know is justice, equity, good conscience. That's it. So this we have to know. Okay, justice, equity, and good conscience. So normally when laws are written, we'll refer the law. But when any written law is not applicable to a legal matter, any matter is not prescribed by law how it is to be dealt, then it will be decided on basis of the justice, equity, good conscience, which means fair, reasonable, morally just. Learn these words. Done. Fair, reasonable, and morally just. Okay. It was held, or the similar thing was held in Waghela Raj Sani versus Sheikh Masluddin. Okay, that we can refer it for justice, equity, good conscience whenever it is silent. But however, if we are applying, we have to ensure that any English common law that we are applying, so laws are two kinds, commercial and common. So common law, when we are applying, we have to see that it should be coexistent with the Indian culture. You cannot blindly follow it whenever we are applying justice, equity, good conscience given by the it was given, it's a matter, it was formed in UK by the Implees Regulation 1971. They had made this concept of justice, equity, good conscience. The doctrine was formally introduced through the Implees Regulations of 1781. But when we are applying in India, we will ensure that it should match with our customs. Okay. Supreme Court also held that in case of absence of any Hindu law, courts may decide on basis of justice, equity, good conscience. Okay, so you can write that also. Now sources of English law. Now how was English law made? Similar to how Indian laws were made. Common law, commercial law, justice, equity, good conscience, and law and statutes. Common sense, how we made, they made. Mercantile law, again very simple for us also. Now what were they saying? Mercantile laws in India. Contract Act is of which year? I told you. Common law is other than commercial, and then is commercial law. So commercial law, that is also called as mercantile law. When was the Contract Act made? 1872. Prior to that, how we used to deal contracts? It was being dealt with the personal laws of the person, parties, Hindu, Muslims, etc. Then later we had Sale of Goods Act, Partnership Act, Negotiable Instrument Act, etc. Okay, that's it. Similar things you see they've given for Indian laws also, and we are done with the entire chapter. Okay, nothing can come outside of this chapter at all. We've completed every single thing, and that too from the latest module. Okay, if you go to see your Rossi, we are seeing the past exam questions. Is that we've covered everything or no? So first, as I told you, they ask exam questions. Always I tell in the exam, in my lectures also, their first question they've asked in June 2025, Rossio bound, about classification of interest. Then in December 2024, they have asked about judicial precedents. Okay, and various kinds of precedents. So we've done that also. Okay. Then in June 2024, they asked about Jeremy Bentham. Okay, Jeremy Bentham also they've asked, pain, pleasure, two things. But the most important thing was the 8 different things. Right? We've done that also. Then they said in India, again, let's see which question is this. And the norms, Grund norm, Kelsen's theory they have asked. Okay, they have mentioned Grund norm. So you have to click. Even sometimes you have to think that this Grund norm is about Kelsen. That's how they asked here. Then in December 2023, they've asked High Court, Supreme Court, customs, the essentials of a custom. All we have done, and I guarantee you, not a single question can come outside than what I have done in this lecture. So your job is to just go through it and learn everything perfectly. You can see all the past exam questions also I've covered. Ratio, decidendi, obictor, dicta. Okay. Then we have Kelsen's theory. No, again they have asked Kelsen's law, repeatedly asked, and that's it. Okay. So with this we have completed entire lesson one and in a span of 1.5 hours. Okay. So we are done with that. Now we'll start with another chapter which I will just quickly complete it also, that is interpretation of statutes. I will start with interpretation of statutes and complete it. Then we'll go to the next one. Okay. Because constitution again is a big chapter. I don't want to. Okay. So now we'll be looking at the interpretation of statutes. Okay. Then we'll do later constitution. First we'll finish this chapter, as many chapters as we can complete. We'll just take a 2-minute break and then we'll start. Till that you all can just revise. Okay, so we'll just restart in 2 minutes. Okay. So am I audible to all of you all? Put GTG in the chat box. Am I audible to you? Sir, where we will get the past exam questions and answers. I have put it on my website in the free resources section. Over 5,000 plus students have downloaded. The answers are with the model answers as per ICSI. Okay. So now we begin with the next one. Let's start. Just write GTG in the chat box so I know you all are with me. Am I audible and visible? Yes or no? Quickly, I'll be finishing the other stuff also. Chalo, let's start. Pradeep, Darshini. Great. Hi. So we'll be starting with a chapter called as Interpretation of Statute. Now, interpretation means understanding a statute. Statute means a law, an act, any kind of bylaw, anything that is there. Now, why would I need to understand a statute? So normally the parliament makes the law, they make it, and every person follows the law. But there are times when in any particular law there is a confusion, or the words you need to know is ambiguity. What is the word? Ambiguity. Ambiguity means confusion. So whenever there is a ambiguity in any statute, interpretation is required. Whenever there is any ambiguity in any statute, interpretation is required. So to interpret means what? Interpretation means to explain, understand, or translate the law. Okay, it means to translate the law. Now, to translate the law, the courts have made certain rules. Okay, primary rule, secondary rule, Hayden's rule. We will see all those rules, and one rule again comes in the exam. Okay, so let's start. The first one is a primary rule. Today, if you don't understand a word, where do you go? You open the dictionary, you open any interpretation, and you go as per the grammatical meaning of the word. Now understand, just understanding the rule is not enough. Using the words that law has used is important. So primary rule is also called as literal or grammatical rule. It's called as a golden rule. So it says that now understand the words that they're using. Okay, any words, phrases, sentences should be understood in their normal, ordinary, popular and grammatical meaning, unless they lead to absurdity. So whenever there is a confusion, absurdity means stupidity. If I try to apply a dictionary meaning and I don't get the I feel it is wrong, I should not apply it. So primary rule says apply the dictionary. It's also called as the dictionary rule. If applying the dictionary meaning, you can understand the context of the law, it should be applied. Okay, now interpretation by applying the dictionary meaning or the popular meaning should not be such that it is making the act redundant or any other law redundant, etc. It should not make any other thing ineffective. So when I fix a dictionary meaning, it should give perfection, it should complete it, it should not create issues. And there are some rules that every word is relevant and the object of the act should be fulfilled. Now, obviously, if this was the case, just by reading up the dictionary, that doesn't work, right? Mostly it falls under case 2. What is case 2? Case 2 is a rule of reasonable construction, which says, you have to start with the primary rule. You have to say that whenever any statute is ambiguous, then we should apply the dictionary meaning. Then continue with the word however. Then you say however, if that does not serve the purpose, then depart from the dictionary meaning and apply a logical meaning. Okay, then what we will do, we will depart from the dictionary meaning and apply a reasonable meaning. So courts are allowed to modify the meaning of the term and apply a sensible and reasonable meaning. This is the rule of reasonable construction. Simple. Okay. Again, you will write this line everywhere that the object of the act and the subject matter of the act should be fulfilled. And never you will apply any meaning which will divorce it from common sense, which will make it irrelevant to use. So let's take few examples. Okay. Lee versus Knapp. Now, what happened is in the Motor Vehicles Act, in the Road Traffic Act, it said that whenever there is an accident, you should stop. The question came that what do you mean by the term stop? Stop in the dictionary means halt. But here courts modified the meaning, saying that halt for such a reasonable time that inquiry can be done. The extra part was added by court to fulfill the object of the act, that if an accident is there, we want you to stop so that we can do the inquiry. Similarly, there was another case of assessing authority versus Patiala biscuit manufacturers. What did they say? That listen, you should be in possession. In the data said that whenever you government is saying that you should be in possession of the certificate. So if any license is required and I possess the certificate, I feel it is good. But authority came, I was having dinner and they come and they say, show me the certificate. I say, what do you mean? I don't have it right now. Whereas when you see the dictionary meaning, possession means physically possessing it. So then they modified the meaning of the word. It does not mean actual or physically possessing it. It means you should have acquired it and you should be able to present it within reasonable time. Okay. Then, so we did the first rule. What is the first rule? Primary rule. Then came the second rule, which is reasonable construction. Now coming to rule of reasonable construction. What does it mean? Now we're coming to the third one. Okay, rule of harmonious construction. Harmony means what? Peace. And construction means interpretation. So do a peaceful interpretation. Now pay attention when it comes. If in one act only there is two sections conflicting with each other, so there is a head-on clash. There is a head-on clash between two provisions of the same enactment of the same law. If in the same act only there are two sections conflicting, then interpretation should be given such that effect can be given to both. That means in one act, I think that two laws are contradicting each other. So my job is to interpret in a harmonious way that I can make both valid. Okay. So let's take an example. So what happened in Article 19(1)(a), it has said you have a right to speak whatever you want. And in Article 194, what did they say? That parliamentary privilege, that you cannot, what has been discussed in parliament, you cannot go out and speak. Common sense, like that in a board meeting, I cannot go out and speak. So these two are conflicting with each other. One is saying you should not speak and the other one is saying you can't speak. So then the harmonious construction was that, listen, freedom of speech and expression has some limitations. This is falling under the limitation that if there is some trade secret or in the parliament if some secret thing is that you cannot go and inform it to others or reveal it. So this is the rule of harmonious construction. Then comes one rule which is called as rule of ednis generis. It means the same category. So when I'm interpreting words of same category and there are some specific words, okay, which are there of a category, specific words of category. For example, arms, ammunition, gunpowder, etc. So there are some specific words, and after that, a general word is coming. General word is like an etc. or any other goods. Then the interpretation of that etc. or any other goods will have restricted meaning to the class of the original category. Let's take an example. So let's take an example. This sounds difficult, it's very simple. So there was AG versus Brown. Under section 43, the Customs Consolidation Authority was empowered to prohibit and importation of arms, ammunition and gunpowder or any other goods. So importation of arms, ammunition, gunpowder. Can I say all these are specific words of a category? They all are words of a specific category. They all are followed by a general word. So general word came later. A general word is like an etc. Does etc. mean anything? Etc. actually means anything. Any other goods means actually anything. But here these general words will have restricted meaning to the words of that special class. So any other goods means what? Only related to arms, ammunition, gunpowder. So what is adding generis? All the goods of the same kind. So whenever there are some general words like etc. which follow a specific words of a distinct category, then the general word etc. will have a restricted meaning of that category. Simple, perfect, next rule. Mischief rules, Hayden's rule, or also called as purposive rule of interpretation. Also called as purposive rule of interpretation. Now pay attention, okay? In Hayden's rule, it was said that, if, now pay attention to this, okay? Hayden's rule, also called as mischief rule, Hayden's rule, or purposive rule of interpretation. Now why it is called Hayden's rule? Because it was laid down in Hayden's case by judges, but judges that time were called as barons of exchequers. Okay, so barons of exchequers are judges of olden times of UK. So in Hayden's case, what did they say? That if any statute you want to understand, you have to do 4 things. Go back to the common law before the act. Go back, for example, if I am taking Companies Act 2013. Which was the act before that, before Companies Act 2013? Let me know in the chat box. Companies Act 1956. So, if I want to understand Companies Act 2013, shouldn't I go back to the common law before the act? I'll go back to the old act. So I'll call it as the old act. I will look at what all defects were there. I will look at the defects. Defects did not talk about anything about online and digital, and everything changed. The world changed after that. So then they said, let's have a new act altogether. So I saw that digital presence a lot was mentioned in Companies Act 2013. Then what remedy was provided in the new act? And what was the true reason and the object of the act? So with this, anytime if I want to understand any law, I should know the background, the foundation to get a good understanding. So for interpretation, go back to the old law, study it, see what defect it had, see what remedy was provided in the new law, see the true reason of the remedy, and that is it. With this, I will ask what will happen? What will happen because of this? So then I will be able to suppress the mischief, and advance the remedy. I'll be able to suppress the mischief and advance the remedy. Then comes other rules of interpretation. Now pay attention. So all these main rules are over. Now some other rules are there, but sometimes they ask these other rules also. So if I say that all boys are present, that means who are excluded? Girls are excluded. So just remember from these Latin word exclusio, exclusio. You have to understand that express mention of one thing means the exclusion of another. If I expressly mention that boys are mentioned there in the room, then that means that all the girls are excluded. So express mention of one thing implies the exclusion of the other. Okay. So for example, in the constitution, if they say that only citizens can vote, that obviously means that foreigners are excluded. Then comes contemporary. Now just from this word, just remember contemporary. Contemporary means what? Contemporary. So I am your contemporary. All those living at the same time are contemporaries. But are we and Gandhiji contemporaries? No, because he is already not there. So he is there of a different time, era. So if I want to understand any law, they are doing interpretation, how contemporary came. So they are saying become a contemporary of the makers. So when the law was passed, how the people there were thinking, behaving, what scenarios they were facing. So simple word, step in the shoes of the maker. So contemporary means that the best way to give and understand a document is to read it as it would have been read when it was made. Clear? This is an important line. Then nostre socius. Nostre socius means preceding and succeeding. If I don't understand a word, I will go to the preceding words and the succeeding words to understand the meaning. So a nostre socius means it will a thing can be known by its associates. So you can know any particular meaning by its associates from the words that come before, preceding it and succeeding it, associating it. Strict and liberal construction. Now this is also very important, strict and liberal construction. Now always remember, strict interpretation is for two cases only: penal statutes and taxation. Nobody wants to be penalized and nobody wants to pay unnecessary tax. Am I right? So here the law is saying that listen, this is puts a burden on the person. So therefore, only if the person falls exactly within it, then put them in jail or then put tax on them. If there is a doubt, can you put tax or put them in jail? No. If anything is on the line, middle, on the fence, will you put or not put? Penalty and him in jail? You will not do. So again, strictly if the person is falling within the law framework, only then the person will have penalty or taxation. So criminal laws have strict interpretation. Unless the person is found guilty in strict terms with clear evidence, they have a words in law that they say beyond doubt. Okay, so a person should be convicted only if it is beyond doubt that he has done it, then only he will be there. That applies not only for taxation but even for criminal laws. Now coming to the other one, beneficial or liberal construction. Now as I told you, in strict laws, if it is on the line, we don't put the penalty. But here, if it is a welfare legislation, if it is on the line, on the fence, benefit is given. Okay, so beneficial legislation have liberal interpretation. Okay, fine, even if it is not strictly there, give it. But they will in strict, they will not say if it is on the line, give him jail. That they will not do. It burdensome. If it is on the line, give him taxation burden. No, that doesn't happen. In liberal, very simple. Only if since it is a beneficial, if it is on the line, they give it. For example, there was a case where the employer had to give 4 weeks salary. How many weeks? 4 weeks salary. So what did he say now? That listen, the lady used to work only from Monday to Friday. Saturday, Sunday I won't count. So liberal legislation, so government said no, give for the full week. Don't just count Monday to Friday working days. Welfare legislation. If a person has disablement and compensation for partial is 50,000 and for complete disablement is 1,20,000. So government can take the route that let's give him 1,20,000 compensation. Then comes to aids for interpretation. Aids means what? To help you understand the particular law. The act itself has many aids. One is internal aids, means within the act itself. One is title, Companies Act. It is a short title, Companies Act 2013. But if you read the long title in section 1, the long title will be given that this Companies Act, this has been made to consolidate the law relating to companies and amend everything. So that's a long title, that's section 1. So always section 1 has the title of the law. Always in every single act, the section 1 will have a long title and a short title. A short title is direct name, a long title will be a law to consolidate. It always starts like this. Then in some of the acts like your constitution, you have the preamble. The preamble gives you a window into the mind of the makers, uh, the key aspects of the constitution will be laid down in the preamble. Headings, so you have chapters of Companies Act, directors, meetings, there are separate chapters. Dividend, marginal notes. So these are also called as side notes. So sometimes in some laws, like in criminal laws, some property acts, etc., in the side only they give some note called as a side note, helps you assess, helps you understand it better. Some examples would be given, illustrations would be given, etc. So like there was in the Bharatiya Nyaya Sanhita, the criminal law, what did they say that if robbery is there, then they've given an example in the side that even if someone makes a duplicate uh, key and enters in, that can also be treated as robbery or a house breaking. Window is open and he has entered. So examples can be given in the side, and those are called as side notes. Interpretation clause is always section 2. Definition has been given in everything. Then comes proviso. Now proviso is important, just understand. A proviso we've always from childhood in law been learning provided that. Now provided that has two purposes. Always a provided that will have two purposes. Either it could be for a qualification or an exception. What? It could either be there for a qualification or an exception. Qualification means what? Provided that you have a DIN number. Provided that you are a citizen of India. So it is saying that this qualification you need to have, then this law will apply. Exception could be that four board meetings need to be done, provided that small companies have only 2 board meetings. So what is that? What is happening is they are creating it, provided that they are using it either as an exception or as a qualification. You will always see whenever next time you are reading a proviso, you always see whether it is made for an exception or a qualification. Illustrations, examples are given, schedules are given within the act itself. Now when the act itself is insufficient, or the act, when I try to interpret and I cannot find within the act solution, then I look outside the act. For outside the act, I will go for different things. One is a dictionary, simple little things. Now when the act was being made, a committee must be formed. An expert committee would have been formed. Okay, for let's say Andyaru Jinnah committee was made, IBC code was being passed, or we had different committees. For GST we had a different committee. So we look at the committee reports to understand the law better. Parliament history, what exchanges happened during the parliament, their speeches, we can study all of this. Then one very important thing which is called as statutes parimetria. Statutes having the same material, same contents can also be referred. Companies Act 2013 and Companies Act 1956 are statutes in parimetria. Okay, or I could say Competition Act and MRTP Act. Both had the same subject matter. So even that could be studied. Dictionary, foreign decision. So these are the things that will be seen. Now presumptions, not very important, but we'll just see. What do you mean by presumptions? Presumption means certain beliefs that we will have, default belief. We will always presume that the parliament knows the law. We will always presume that the parliament does not make mistake. We will always presume that mens rea is required for criminal acts. We will presume that the legislature knows the law, legislature knows the practice, legislature does not make any alterations, okay, without express enactment. Doctrine of natural justice must have been followed. So these are all presumptions that we will make, and these are all presumptions in favor of government. Okay. That's it, and we've completed. So there was one case law, authority. Okay, now this is one case law added in the amendments, that the Supreme Court held that a tax exemption entry clearly and ambiguously mentions hank yarn. The benefit of it cannot be restricted only to cotton yarn. The issue involved whether the exemption was given to, it's a type of material, okay, applies only to cotton yarn or to the handloom industry. Now, if you go to see, now this is in the industry specific, the Supreme Court observed that hank yarn is the exemption entry clear, specific and free of ambiguity. The exemption cannot be restricted by referring raw materials or intended user industry. If the entry benefits other industries, there is no legal basis to deny them exemption. The Supreme Court held that the exemption for yarn applies to all types and the restricting would be rewriting the law, which is not permissible in statutory. Now again, why did this happen according to you? So what did they say, that does it apply to other cotton yarn? Answer is yes. So does the benefit, now again I'll tell you in short what happened in this case. In Alkavi versus spinning mills, hank yarn was there. Okay, benefit was given to hank yarn. Now this guy, what did he make? He made cotton hank yarn. So which should the benefit be given of tax exemption? This, now if you also get confused, always remember this is it is a beneficial law. Exemption is being given, tax exemption is being given. So interpretation will always be given in a liberal manner, that exemption is taken. You can take it away. Okay, so burden is always strict. Benefit is always relaxed. So even yarn, cotton yarn manufacturers also got the benefit. So they all became happy. Very simple, and we have done with the entire chapter. There is one part which is called as General Clauses Act, which we will take in the next session, in the tomorrow's act as well, and how to read case laws. This we will take it tomorrow. Okay. With this we have completed entire iOS chapter. Now we'll go to another chapter which we can call it as, which I should take, Civil Procedure Code. Let's take a chapter. So we finished interpretation. Now let's see, Right to Information Act also will complete. It's a small act and it's a 6-marker act. Okay, so we can nicely complete right to RTI also easily. Okay, so now we'll be starting with RTI Act. It's a 6-marker chapter. 1 5-mark question has to come. It's come in every attempt. Okay, so and the chapter is also very easy, achievable. Okay, great. So this I think we'll complete it in 15 minutes max, the entire chapter. So it's easy to do and easy and scoring also. So let's not delay on it. We'll complete it as well. Hi. So we'll be starting with a chapter called as Right to Information Act. Now what is this act about? This act is about the right of citizens to take information from the government records and government officials. So what is this right? This right is right of citizens to access information under control of government, or they will use the word public authority. Okay, simple. Now let me ask you a question, and even I have taken a video on how you can get your answer sheets from RTI from ICSI also on YouTube. If you check how to get your question papers from RTI, I have taken a video on that. So I'll tell you in short what it is. Now let's say this is a citizen. You are a citizen of India. Now, what happens? You go to the government officials, okay, public officials, government department, BMC or any kind of municipal body, any RBI, any government hospital, any police, okay, anyone. Now, government body. Sir, what do you mean by government body? Can I go and ask information from a private body? Obviously not, because it is private and it is not government. So how do you define this body? So basically it should be either set up by government or funded by government or managed or interlinked between government. Then only we can ask. Okay. Now I go to the government body, I ask that what happened to my application, why you're not passing it, you've cancelled my license, I want to know the reason why. They say get out. I don't want to give you, because it's a normal pattern of any government officer to tell you go away. What will you do? Then the citizen of India, they will use the RTI. So they have made a PIO. What they have made? I want all of you to tell. Public Information Officer. In every single government body, there is a PIO made. So the citizen will write an application. So I try to access information from government body which they denied me. Then I will write RTI, I'll file RTI to PIO. And then the PIO will contact the body and retrieve the information and give it to me. Normally within how many days? I'll get? And how many days the government official gives it to me? Any idea? 30 days. How many? In 30 days, it is their duty of the public officer to give me the information. Now, what if the public officer also became corrupt? Then the government has made information commissions. What they made? Information commission. So if I am unhappy or within time limit the PIO did not give me the information, I will go in appeal to the information commission. Concept clear? Now first we are just understanding the RTI Act. When did it come into force? It came into force on 12th October 2005. Fine. Now it touches upon two articles, very important. Article 19(1)(a) and Article 21. See, two articles will be touched here. Can you tell me which two articles of Constitution? See, can you see which two articles are there? Did you know that in RTI two articles are hit? Article 21 and Article 19(1)(a). Okay, now let me tell you how it is connected. So what do they say? Article 19(1)(a) talks about freedom of speech and expression. So only if a person gets information, only then he can speak. So that became connected. And the second is, this is very important for a citizen of India for his right to life. Article 21 is right to life. Right to life includes right to vote, right to participate in democracy. So now if I am not getting information only, how will I participate in democracy? So therefore they say it helps you to participate in democracy. What is the keyword used? Participatory democracy. So only if I get information under, then I will be able to speak, and then I will be able to participate in democracy. That's how the two articles have been hit, and I expect you all to know. And they have a given case law also, objective of the act. I have explained the full object of the act. You can write it in Anjali Bharadwaj versus Union of India. Object of the act you will write is given in Anjali Bharadwaj versus Union of India. And the Supreme Court held that there is a link between information, right to information, and good governance. Today, if you get proper information, you will raise questions and there will be good governance in the country. Okay. So the case law I want you to write if this chapter comes, Nobody will write, but at least I expect you all to proactively write this in the exam. Now coming to the definitions. First is public authority. Sir, why public authority we need to know? Information from whom you will ask? Public authority. So public authority means what? Any RBI, any authority. So you see anything set up by the constitution, set up by the government, or managed by the government, or subordinate to the government, etc. And from then I will ask information and records. So what records will you ask? So now again, if I ask for information, you think he will call and tell me the officer? No. Now I have to tell him the mode in which I want the answer. Either documents, copy, microfilm, CD, anything. I can tell them that give it to me in this order. Pen drive. Now, which chapter we are doing? Right to information. What is the definition of right to information is given here under section 2J. J for what? What is my surname? Okay. So J, you can remember, is right to information. Okay. Means what? The name of the chapter. It's a right to obtain information which is accessed, which is under the control of the public authority. Right to information means you are trying to access information which is under the control of the public authority. And you have a right, and includes the right to take copies, inspect the work, take samples, copy floppies, etc. Clear? Now we did section till here. See, we are doing all the sections. Now we'll start from the main one, section number 3. Obligation of public authority. Tell me one thing, if a public authority or a public department has not kept a PIO, can you ask for information? Who will give you? Who will give you information if there is no PIO? Correct. So the law has first put an obligation on the public authority. See, every public authority shall maintain all records. First, publish within 120 days from the act that they have appointed a officer also. See here, section number 5. Every public authority has to designate at all the units a PIO, and at subdivisional level assistant PIO. So that's what my question was, that if the PIO is not appointed, who will you ask information from? Authority themselves are not ready to give you. So section 5 is putting a obligation on the department that first you put a PIO, then the system works. Then we will obtain the information. So now section 6 and 7, okay, request for obtaining information. So I told you within how many days the information is given? 30 days. But if I give it to assistant guy, it is 45 days. See, if it is information is to be given in 30 days, if it is to assistant, then for 35 days. Very important. If I give it to junior guy, he gets 35 days to give me the obtain and collect and give me the information. If let's say there is a very serious matter ongoing and the court is saying that this person is no longer going to live, they are on the deathbed, and we require this medical report from the government hospital. So then even you can apply that someone's life is involved, life and liberty is involved, give me the information, then they will have to give you in 48 hours. Okay, if no reply is given within the timeline, then it means it is refused. Okay, and if it is concerning the interest of a third party, then 40 days is given. Third party means what? I am asking from the government body, like ICSI is a government body. I am asking your membership number. I am asking for your passing details. Now someone is saying that, listen, this guy is asking a third party information. So then they can give it to you in 40 days. They will require some more days, but they will get you in 40 days. Is this clear? Timeline. So what are the timelines? 30, 35, 40, 48 hours. Right. So if we just take a recap. It is what all days? 30, 35, 40 and 48. Perfect. Perfect. Very good. Yeah. And section numbers also we can remember in sequence only. Section 5. You can start it off from section 5. Appoint the PIO, then he'll give you the information in 6 and 7. Okay. And section number 8 you need to know by default. Information which cannot be given. So I want all of you all to quote in the exam. Okay. Section 5, 6, 7 and 8. That's it of RTI Act. This is the most important. What is section this? That public authority will have a PIO. What is this? The timeline. Time limit to respond. And this exempt information. What is this? Exemption from, very good, disclosure. 8 to they ask multiple times, but if you remember the sequence, you will be able to write and nobody else will be able to write. Right, then we come back. All these duties of PIO is same as what we have done above. Only one additional point is there, that if you go to wrong PIO, then he has to transfer it within 5 days to the other guy, to the correct PIO. So if I give a wrong application to the wrong PIO, then within 5 days he gets to give it to the correct department. I can't say that you listen, you get to the wrong department. Then it's my job in the next 5 days to submit it to the right department. Then Central Board of Secondary Education said that indiscriminate and impractical demands under ITI will be counterproductive. Means someone is unnecessarily filing RTI to ask section 8 information, wrong information. So it will become counterproductive, yes or no? The act should not be allowed to be misused and abused to obstruct national development. It is there. So that also they have to keep in mind, that unnecessary someone is asking information which they don't require or which is against section 8. So they should be rejected. Section 8, very, very important. Exempt from disclosure. So let's say, for example, if I'm asking for trade secret, it won't be allowed. So some information which cannot be disclosed by government is given here in section 8. Sovereignty, integrity is affected. It is forbidden by court. So if you remember the Babri Masjid case which was there, what happened? Government said that don't reveal the judgment only, because it can lead to communal tension. So that also I cannot then unnecessarily. Also they said for a good number of days, don't disclose it. It's very crucial. Then breach of parliament privilege is exempt from disclosure. Breach of parliament privilege, obviously, if I'm asking what government in meeting, what happened, tell me. Breaching the parliament privilege, that also. Trade secrets, commercial confidence, intellectual properties, those details cannot be taken. Any information received from foreign government, any information which will endanger the life of a person. How can any information endanger the life of a person? Can you tell me? Whose information I must be taking that I will then go and endanger? So basically, let's say if someone complained about me and I want to know who complained about me. So can I say his life is in danger? So let's say if they call it as informants about any criminals. So let's say they have told that if an informant is there, he went and he told that I have seen this criminal here, and they want to know. So witnesses are perfect examples here. Witnesses of crime are there. Anything that will impede the process of investigation. Okay, during the case only you want to know the details of the witnesses, etc. Then it will impede the judgment. Cabinet papers, again I told you that what is discussed in parliament and cabinet is exempt from disclosure. And personal information which is an invasion of someone's privacy. Okay, if I want to know whether the person has changed from male to female, personal information, medical reports which is not affecting anyone else, so that cannot be done. Then obviously they have a right to reject such information which is under section 8. What if I ask a mixed, imagine in the application I make an application, in that I'm asking for valid info and I'm asking for invalid info. Will the entire application be rejected or only partial information will be disclosed? Only the valid information will be disclosed. Very good. Then who is excluded? Information with respect to all the central and state agencies which are there. Okay, your narcotic, your RWB, your CBI, your CID. All these informations cannot be disclosed. Then I told you, if you're unhappy with the decision of PIO, who will come? Information Commission. At the central level, you have central CIC, and at state level, you have state CIC. Okay, they are made by central government, so obviously, president will be there, and obviously, they should not be connected with any political party. Similarly, then you see they are appointed for 5 years. Age limit has been given. They should be persons of obviously experts will be appointed who has a wide range of knowledge in science, commerce, law, journalism, etc. They can be appointed. State, again similar, everything is same, only difference is this is by state government, state CIC, and not by president, by governor. Okay. Now again, whatever, if what these commissions will do, what are the powers of these commissions? So obviously they will overlook the PIO. Okay, if any information has been rejected or not have been, PIO is not appointed, no response has been given, fees charges unreasonable, false information was given by PIO, then they will investigate into the complaints. What do? They will receive complaints with respect to PIO. If you're unhappy with the Information Commission, PIO, where will you go and appeal? Information Commission, as I told you. So if you're unhappy with PIO, within 30 days, assistant PIO, within 30 days you go to PIO. If you're not happy with PIO, you go and appeal to Information Commission. Then they've given you penalties. What are the penalties? That listen, if the section 20 says that Act imposes penalty on the PIO for failing to provide information, it will be liable for 250 rupees fine, maximum 25,000 fine will be there for not accepting. Now, when you will put a fine on PIO? When you will give a fine on PIO? So basically, when they are not accepting, they are dealing, denying, giving incomplete, destroying, or obstructing information, then they will be there. Okay. Then one case law again, which they have given in the recent times. Okay. Supreme Court held that CIC possesses power under Section 12 of RTI to frame the rules, regulation, form the bench, and necessary measures to manage the information. The Supreme Court held that object of RTI is to promote transparency and accountability. To fulfill the goal, efficient functioning of CIC is essential. Held that under Section 12 grants that CIC implied authority to form benches. This ensures timely disposal and strengthens the right to citizens. So very simple. What did they say? That they have powers to form their own benches and allocate the work, delegate the work, and all the administrative powers also they have. Common sense. Okay. With this, we have completed the entire RTI Act 2005. Thank you. So we are done with RTI Act also. Then we are done with your interpretation. We are done with sources of law. Then we'll also complete right now your civil procedure code. Very simple civil procedure code, 8-marker chapter. We'll knock it out as well. Okay. Okay. So now again, I'll just go through the past exam questions of civil procedure code. We'll just start in 1 minute. Okay, 1-2 minute break and then we'll start. Ready? Write GTG in the chat box so we can quickly start and complete this chapter as well. And when we do it, we cover all the things from the module, everything that has come in the exam, that can come in the exam. So you know that beyond this, nothing really comes. GTG in the chat box. Great. Chalo. Now we'll start. Now we'll be starting. Yeah. Hi. So we'll be starting with a topic called as Code of Civil Procedure 1900. Now we know civil matters and criminal matters, there is a difference. In civil matters, the procedure that is followed is in Civil Procedure Code 19. For example, if there is any kind of a trespass or if there is any kind of a breach of contract, there is a procedure given and that procedure is to be followed under property disputes. All of that, the procedure is followed in 1908. When we start, let's look at few important terms in CPC. Judgment, decree, order. What do you mean by judgment? So when I was also there, I was interning under my uncle. He asked me, what do you mean by judgment? And I'll also ask you all, what is the meaning of judgment? That time I also gave incomplete answer and I'm sure you will also give an incomplete answer. What do you mean by judgment? Write in the chat box. But what if it comes in the exam? What? Very good. So this also, I also said the same thing. A judgment is basically opinion of the judge, right? But I also said the same thing. It's a half answer. Opinion of the judge and the reasons thereof. Why is he coming? Because judgment copy will not be hang him to death or tell him to pay 50,000 rupees, because that is his opinion. But why he gave that opinion is equally important. So read this. See, the statement given by the judge and the reasons, and this is given in section 2 subsection 9. See, very clearly it has been given. The statement given by the judge and the reasons thereof is called as judgment, and this judgment is based on reasoning, and this reasoning is given in your decree. It is given in decree. You can see this on grounds of decree or order. Now let's understand what do you mean by decree. So a decree. Now we are understanding the meaning decree. Now what does decree mean? So can I say that in a particular case there will be many controversial points? Yes or no? There will be multiple controversial points. Now when each one is identified, let's say there are 3 controversial points, each one will have to be identified, heard, both the parties will debate on each point, and then we will say that whether the plaintiff won or the defendant won. Here the plaintiff won, here the defendant won, here the plaintiff won. So on basis of the decree, on all the decrees, the judgment will be passed. So how do you define a decree now? So can I say that a decree conclusively determines the rights of the party? So what am I doing? I will determine completely that this guy is right or this guy is right or this guy. So I am completely deciding a matter in controversy, and on basis of the decree the judgment will be given. And this decree could be a preliminary decree or a final decree also. So temporary and final, both orders I can give you. So let's see. Now you think the judge is telling it as a joke or he is serious? So it's a formal expression, not a casual statement. So it is a formal expression in adjudication. In adjudication means in the court process, where the judge conclusively determines the rights of the parties with matter to all or any of the controversies, and it could be the preliminary or final. Beautifully explained. Let's take a recap. It is a formal expression, not a joke, not casual, which conclusively, finally decides one entire matter. Okay, with respect to a controversy, contravention in the suit. One party saying this, one party saying that, and so the judge will determine that this guy is right. In another matter, this guy is right. Basis of all of that, the judgment will be given. So that's why when you see on grounds of decree, Now coming to the next thing is, the one who wins the case is called a decree holder. The one who loses the case is called as decree judgment dater. Order. Now what does the term order mean? So the one who won the case is called as decree holder, in whose favor the decree is given. Against whom it is given, it is called as judgment dater. Order. Sir, what do you mean by the term order? So order again means a formal expression which is not a decree. So again, when a judge passes an order, is he joking? No, he's giving it's not a casual statement, it's a formal expression. But it doesn't decide the rights of the parties, because the rights of party, when it decides, becomes a decree. So let's take an example of few orders of the court. If I tell your brother also to come to court, is it an order? Yes, because a formal expression is there, but I'm not deciding who's right or wrong. If I tell that this letter is given in Chinese, translate it and get translation copies, it is an order. If I tell that get the document of your MOA and come, that is also an order. It is not determining the rights of the party, but it is a formal expression. Difference between decree and order: decree conclusively determines the rights of the parties. Who's right, wrong? Order does not. Obviously, if something has gone against you, decree, you have a right to appeal. But order, has it decided anything? So ideally, you don't have a right to appeal. Normally, orders are not appealable. You're not determining anything, right? It's just a procedural decision. So this determines the rights of the parties. Decree, order does not. Decree is always appealable because they have decided something against you or in your favor. Okay, order is not always appealable. Okay, very rarely they will let you go from an appeal. Now let's look at an example of an order. Another example from an order is interlocutory order. Interlocutory means interim order. Now one example of it they have given you is power of interim. So let's say if there is perishable goods. What goods? Perishable goods. Perishable goods have long shelf life or short shelf life? Short shelf life. Okay. So if it has a short shelf life, and let's say two people are disputing that this particular goods are mine. Now till the time we decide, the goods will get spoiled and we will have to throw. So what is the best thing? That the court gives an order that sell it in the market, the money keep it aside. The money will not depreciate or get spoiled. So a court order to sell perishable goods, okay, subject matter which is speedy decay, is an example of interlocutory order that you asked to sell the. Now again, when any person will go to the court, what do you think the judge will first ask? What the judge will ask if someone has come before you? What is the issue? Why you have come? That in legal words, what we will call it? Cause of action. Cause of action means, you say cause of action, I don't know. That is exactly what you will, which you have just told, that what is the issue. So the cause of action is, they are asking that first there must, like, what is the reason for filing the case. So you will have to explain yourself in two ways. What you will have to tell, that sir, I had a right, I had a car and this guy banged my car, so he infringed my right. So this is, you have a right and that right got infringed and that led to a cause of action. Reason for filing the case. Reason for filing. Is the concept perfectly clear? Now coming to jurisdiction, very simple. Jurisdiction, for every lawyer, every law student knows, but they can't define it. What do you mean by jurisdiction? So they say the jurisdiction ideally means the area in which you can give justice, the power how much you have to give justice. Can a Mumbai court pass a judgment which happened in Chennai? No, because they don't have jurisdiction. Territorial jurisdiction is there. Okay, so if a murder is there in Bombay, maybe Chennai will say you can't come here. How will investigate? You go in your area and do. So the jurisdiction means the authority or the power that the authority has to give justice. They will say, I want to help you, but I can't. It's not in my jurisdiction. I go to a judge and I say, please help me. They say, sorry, I'm in family court. You have a labor issue. So jurisdiction means the power of an authority to decide cases. There are different kinds of jurisdiction. One is subject matter jurisdiction. What does subject matter jurisdiction mean? That the family matters is a subject matter. So the type of suit, this matter, only that those matters can go there. Okay, depending on the subject matter of the suit, the court can take up the matter. So certain matters can be taken by certain courts. Family matters, family court, income tax act, income tax court, etc. Territorial jurisdiction. So territorial jurisdiction is fixed by the government. Any matters falling within that jurisdiction, only that authority can take up. Jurisdiction over persons. So like if let's say Obama has come or Donald Trump is coming and he has broken the signal, will you try him in normal courts? No, because certain rulers, foreign states, ambassadors, etc. are treated differently. Pecuniary jurisdiction. If you've read your Consumer Protection Act, so for each type you have a different tribunal. consumer tribunal. So lowest tribunal, what it is called? Lowest consumer tribunal. Biggest, medium, quickly. So obviously the lowest one is called as district consumer forum, state consumer forum, and the topmost is national consumer forum. Okay, so that is pecuniarium. Based on the monetary limits, the courts have been decided. Then you can also classify any case into original, appellate, and both. Okay, original jurisdiction means what? Matter can be tried first there only. For example, in NCLT, matter can be tried first in NCLT. Any company matter can go only to NCLT, National Company Law Tribunal. Appellate jurisdiction. So there are certain tribunals which only have right to take up appeals. NCLAT, National Company Law Appellate Tribunal. So only appeals can be entertained. And some courts have both. Which are those courts which have both? First time also they can take up the matter, and they can entertain appeals also. High Court and Supreme Court. Then comes very important, and multiple times they have asked section number 10 and 11. What is section number 10? Extremely important. Res sub judice. Sub judice means stay of suit. So let me tell you. So the concept is very easy, but to frame it into an answer is difficult. So what happens that they are telling court should not proceed with a matter which is already pending in another Indian court. Finish. You can write it down what I have told you. That no court shall proceed with any case which is pending in another Indian court if the subject matters, parties, and they are litigating under the same title. Common sense. Now why? Now what is the logic that if one court is already taking up, the other court should not take up the matter? What is the logic? Already courts are overburdened, multiplicity of courts will happen, conflict in judgments can happen. This is the reasoning. So no court shall proceed with a trial if the matter is exactly same between the same parties litigating on the same title, plaintiff defendant again, and it is pending in India. If it is pending in foreign, it can be taken up in India, because here only if it is pending in another Indian court will not take it up. Okay, so there will be two suits. One will be filed earlier, and another one is coming now. The new case will be stayed. Okay. Now you tell me logically, if a matter is pending in a court and you have come to me, which rule will apply? Which section will apply? Section 10, we just saw. Now, because matter is ongoing, has it been decided yet? No. If it is decided, it will fall under next section, res judicata. Now understand what is res judicata. If a court has already decided a particular case, so here you will always see that the matter is ended. Court has already decided a matter and punishment has been given. Can on that same matter for the same thing again case be filed? Answer is no, because the party will say, listen, I have already been punished for the same thing, I cannot be punished again. This is rule has to be there. It is called as res judicata. No person should be vexed twice for the same act. So, but rule, what is the ingredients of it? What is the ingredients of it? Okay, requirements that there are one matter which is substantially in same as the former suit, so directly and substantially same. Both the suits have same subject matter. Okay, the former suit has been decided, heard, okay, and it is between the same parties litigating under the same title. Then it will not be raised. Simple. Okay, difference between res judicata and res sub judice. What is res judicata? That matter was pending. Your matter is not pending. Simple. Matter was pending. So we'll say don't come till they file a case. Now there in res judicata, already kata, just remember kata means he has been vexed, he has already been punished. So again, do not vex him for the same thing. Now comes one question, whether consent and compromise decrees between the parties, principles of res judicata, can it apply? If let's say parties have found parties among themselves, they have made a consent, they have a mutual compromise, can it be treated as res judicata that a person has been punished? Means A and B are there, okay, A and B, there was a dispute, they both of them, what happened is they had a compromise, consent order, and now matter is going in court, can it be taken up? Because if it goes in court, court will say, listen, already compromise has been done, will res judicata apply or not apply? Court can take or not take? Cannot take, because they've already, let's read, okay. A consent order, is it decided by the court? Is it a decision of court? In res judicata, what happens? Court has decided, okay. The court has not decided anything. The compromise decree merely has the seat of an agreement between the parties, not a decision of court. As such, the principles of res judicata does not generally apply to consent. This is the first part. We are not finished. They are still continuing. Okay, so don't form your judgment here. One. So ideally, they are saying it's a consent. It's not a decision of court. But when the courts on the facts provided comes to a conclusion that the parties intended that the consent decree should have the effect of deciding the question finally, then res judicata will apply. Means if the parties have said that they want to end it for permanently and no question should ever come up, if they mention that, then res judicata will apply. Normally, if you and me, we have agreed and compromised, res judicata will not apply. But if we have an agreement saying that now this is final, then it will apply. Okay? Yeah. So basically, if I could say that in the consent orders between the agreement between the parties, it should be clearly said that they want to end the case completely and no further matter should be raised. Okay, section 11 of this says that the doctrine underlines the general principle no person shall be vexed twice for the same. However, it does not apply to consent but depends on the court and subject from case to case basis. So in the end, they are saying it depends on case to case basis how the courts could want to interpret. It could go either ways depending on the parties' wordings of the contract. Then we see something important, set off, counterclaim and equitable set off. Very, very, very important, repeatedly asked in the exam. What is set off? I had to pay you 1 lakh, you had to pay me 75,000. So obviously I will not pay you 1 lakh, then you will give me 75,000. What we will do, we will just make a set off and only 75,000 will be set off, only balance 25,000 will be exchanged. So set off is now just learn the language, okay. Set off is a reciprocal acquittal of claims where the plaintiff's claim is set off against the defendant's claim. Okay. I don't use the word set off, I should use the word extinguished. So plaintiff's claim is extinguished against the defendant's claim. Then comes to counterclaim. Now we will see what is counterclaim. Okay. Now first we finish set off. In set off we have an exact amount known. We have the amount known, okay, that this amount is there and this much amount gets set off. A type of set off is called as equitable set off. So first we do set off, then we'll say that one of the type of set off is called as equitable set off. In equitable set off, it means uncertain sum of money. So equitable set off, when you're asking a set off for uncertain sum of money. For example, if someone broke a old antique piece in your house, you cannot find the market price of it. So then you will say, I don't know how much it is there. Uncertain. I'm claiming money. He had to pay me 1 lakh. I also have to receive from him. But how much I don't know. Maybe for example, if someone went and did defamation. Now what is the reputation loss? I cannot tell you exact amount. So when the amount is not known, uncertain, then it is called as equitable. Why equitable? And fair, it is a fair case, etc. Okay. In India, equitable set-offs are recognized. Common law of England do not recognize equitable set-off. And then comes counterclaim. Counterclaim, what happens? It is forming a reverse claim. What do you mean by reverse claim? First, let's read it, okay? In addition to set-off, you can also ask for counterclaim. Counterclaim happens that now they have to pay me. He's the plaintiff, I'm the defendant, my claim is so big, now I am the claimant, he is the defendant. So reverse claim, so set off would be, I just say 75,000 and I have to pay him 25,000. But what if I tell that, no, I have to receive. So when it is the plaintiff versus defendant, so we will say it is set off. But let's say the defendant brought such a big game that now he's asking for 10 crore rupees and this guy was asking only 1 crore. So can I say this could be reverse? So this, now it is happening that it is a counter claim because he is asking claim more than the plaintiff. Then he becomes plaintiff and he becomes the defendant. So I reverse the claim. I change the tables. Understood? Then comes injunctions. Now injunction could be of two kinds. Now understand the meaning of the term injunction. Injunction means to stop, to do. So injunction. Now I want you to just write it down. What does injunction mean? Multiple times it keeps coming. Injunction is an order of court. Is an order of court. Ordering the party, ordering or directing party, one of the parties, to do or not to do something. If I say to do, then it is a mandatory injunction. It is a mandatory injunction that you have to do something. If I say not to do, don't do this, then it is called as prohibitory injunction. If I tell you that you remove the employee, put him back again, that is a mandatory injunction. But if I tell you don't raise one more story, that is a prohibitory injunction. Right? And this injunction could either be for temporary or it could be perpetual, permanent. When it is temporary means, imagine if someone is coming now and he is saying that please pass an order not to sell off the property till the or not to damage the property. So court will say, okay, till the decision or final decision, don't do this. Permanent is if after hearing the entire case we give a final order, that becomes a permanent injunction. Okay. So to do, not to do something, temporary, perpetual. That's it. Now summons. Now if a court has to summon someone, they will send it to the resident of the person. If it is a company, they will send it to the registered office. Now a summons is actually a call. Okay. A summon is basically direction by the court to appear or bring some document. It is always given through one of its officers. It is always given through one of its officers. Now what is a substituted summons? Now, many people know summons means to call someone, court has ordered someone to appear before the court. But if someone is not, and they give the always the summons is executed through a officer of court. Means officer of court will come and tell that you have been called to the court, give me your sign, etc. But what if the defendant is avoiding the summons, not coming to home, not opening the door? If someone is avoiding the summons, then the court will order that the summons be stuck on his conspicuous part of the door or wall or any other. You might have seen sometimes on the door only they stick the entire judgment. That is called as substituted summons. Because we could not hand deliver him, so we are going to just put it everywhere. Okay. Ex parte order. What do you mean by ex parte order? Ex parte order is an order passed in the presence of one party only. Ex parte order is an order passed in the presence of one party only. So if one party is not appearing in court, then what court will do? They will give it in favor of the other party. Now there are 4 remedies. Imagine if the other party against whom the judgment is there, he has a right to go in appeal. What are his remedies? They have asked in the exam. If imagine the defendant did not come and court passed an order against the defendant, what he can do? So he will tell that I was out of India, I was unaware, I changed my residence, anything. So then he can file an appeal. He can go to the same court for review. He can apply for setting aside a ex parte decree just like before, appeal similar, and he can also file a suit on the other side that the other side tried to get the judgment through fraud. So he can separately file a case also on them. Can also file to set aside a ex parte if it is obtained by fraud, but no suit shall lie for non-service of summons. Means if a remedy given to a person against whom an ex parte order is given, he can apply for appeal, which is similar to setting aside. He can go to the appeal is always to higher court. For review, will go to the same court. And third, they are saying that if it is by fraud, I can also get this order copy. Now, very, very important. The next one is reference review revision. Reference review revision. Section 113, 114, 115. Very, very, very important. They ask only in the exam. Reference means what? Reference to high court by subordinate court. So if a subordinate court, let's say, if you don't understand something, you will go to your seniors, right? If I don't understand something, I go to my senior and finish it off. Similarly, if a subordinate court feels that some matter in law needs to be decided by the high court, so they can refer it and high court will pass their opinion. So is there at any time before the judgment, so this is before the judgment, they can refer the same to the opinion. So any court can refer the same to the opinion of the high court. The high court may pass any opinion and order as it deems fit. So who goes to the high court? Subordinate court. Now review. Review always happens to the same court. Review, you tell to review your own judgment. So if any court, if any person is aggrieved, dissatisfied by any judgment, order, they can apply to the same court for review. And court will review only if their mood is there. Only if their what? Mood is there. Now how mood? So mistake apparent on face of record. Okay, mistake apparent on face of record means if they made a very basic mistake. Any other reason, and discovery of evidence which was not available that time. So then only court will review. For example, I go and tell that, listen, a new source of judgment I have, evidence I have found. So then they will review the judgment. And revision. What do you mean by the term revision? So let's say higher court, when they realize that the lower, this is similar to certiorari of Constitution of India. When the higher court feels that the lower court has exceeded its jurisdiction, they will call for the record, see whether you have exceeded the jurisdiction. If you have exceeded the jurisdiction, then they will squash it. So can I say fighting is happening between higher and lower court? So what happens? The High Court may call for the record from any subordinate court. That, give me what judgment you passed. If it appears to me that you didn't have jurisdiction, you failed to exercise jurisdiction, or you pass any illegal judgment, then the High Court will quash the lower decision's order and replace it with the correct order. That's called as revision. Minors can you file a suit on minor? Answer is yes. Now again, I'll tell you also very simple. Now minor has taken some property, okay, and now you can ask to your extent that give my property back. So that also is there, okay. Now let's understand suits by minor. You cannot make him personally liable, but if he has assets etc. which is liable to be given, that can be given. So normally, let's see. So otherwise, it is in normal basic scenario. They say suits on minor is void ab initio. The contract is only not valid, but the benefit taken can be asked back. Now let's see from his assets which he already has. Okay. Now let's look. So that is rare cases, but still. Now let's see. A minor is a person who, now what is the age of a minor? 18 years, but if it is court of wards, mentally challenged, then the age is 21 years. They get more. This is the majority age. The guardian, or we can call it a minor's next friend. Next friend. Now the question comes that when the minor attains majority, then he can decide that the guardian should continue, or he should continue, or he can drop the case also. So when the minor plaintiff attains the majority, he can proceed with the suit or abandon it. So the minor can either proceed or abandon. If he elects the former, that he wants to proceed with him, he can discharge the next friend and he will file the suit in his own. So very simple. If the minor is there, he wants to continue, then he can tell that you leave now, I'll manage myself. Then comes summary procedure. Very, very important. Very, very easy. Now summary means big or small? Small. So it is called as speedy settlement of disputes. Now smaller cases, court will not go into detailed evidence. If let's say a promissory note is there, a bill of exchange is there, contract clear cut is there, so summary suit can be filed. In summary suit, what happens? The court will quickly settle the matter. The opposite side, that is the defendant, will get 10 days to appear before court. How many days he gets? 10 days. Okay, so unless he appears before 10 days, otherwise what will happen? Ex parte order will be given. So this will be a 10 days, I don't come in 10 days, he'll pass away. Ex parte order. Answer is yes. Such leave shall not be granted. Okay. Now obviously you think it is good to give like this judgment. Within 10 days when you pass the judgment. Imagine if you were the defendant. Against you within 10 days is being passed. Your responsibility. So court, what they are saying now, listen, that they will not take such a fast-paced manner, otherwise take all the cases in 10 days now. Why only this? So they are saying that listen, court will not do all these things unless the court is satisfied that the facts disclosed by the defendant does not indicate that he has a substantial defense, or that if the claim is admitted by the defendant. So when they can do summary suits is when they feel that he doesn't have a defense, doesn't have a substantial defense, or second, if the claim is admitted by the defendant, then only they will do summary suits. Concept clear? And the summary suit should be brought in within 1 year from the date when the debt becomes paid. Timeline is 10 days. Now, this place of suing, sometimes they ask in the exam, so let's see and complete it. Section 15. Now, section 15 is the basis of CPC. matter you should directly file in Supreme Court or in the lowest court first. So you will first file the matter before the lowest court. This is section 15, very simple. Section 16 says, subject to pecuniary other limits, the following suits relating to property shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Common sense, yes or no? If property is situated in Mumbai, which court will take up the matter? Mumbai court. So if you go to see, the suits relating to property shall be instituted in court within the local limits of whose jurisdiction the property is situated. So relating to property, it will be instituted in the court within the local limits of whose jurisdiction the property is situated. Now immovable property, for all these matters, it will be taken. Almost all the property related matters will be given. Common sense. Even movable they have given. Recovery of movable property attached with the immovable property. Rent from immovable property, that also can be taken, right? Recovery of immovable property, partition of immovable property, foreclosure of immovable property, compensation for immovable property, etc. Next, section number 17. Suits for immovable property situated within the jurisdiction of different courts. Where a suit is obtained, relief respecting, again, suits for immovable property within jurisdiction of different court. Now let's say there is a bridge. That bridge goes from one place to another and two different courts are coming on this bridge. Start of this bridge there is one court and start of that bridge that court is there. Which court can take up? Bridge is there, road is there, which is so long, which might touch upon multiple courts. Road is also immovable property, right? So now how will you deal with it? So then they say that, listen, if a immovable property is coming in the jurisdiction of both the courts, then which court will take? One line, any court can take up. Even if there is small portion, they can take up the full matter, and as though the entire property is situated in their property, in their jurisdiction, they can take up. Common sense. Section 18, where the jurisdiction are uncertain. Now here we thought the jurisdiction was clear. Even I had, even he had. So they say that even if anyone can take. Now here if it is uncertain, I also don't know where it will come in his or mine. Similar to that. Same logic that any court will take up, they will just pass a judgment. They will pass a disclosure will have to be made that why I am taking it. So when there is uncertainty in the local limits and any of the court is satisfied that the grounds of uncertainty is there is some confusion, then the court will take up the matter. Then any court can take up the matter. Then they can proceed with the case to entertain and dispose of the case, and then it will have the same effect as if the property was situated within their local limits. Common sense. Jurisdiction for compensation for wrong to persons or immovable. Now all this while we were reading for movable or immovable. Immovable property. But now if it is for a human being or a movable property, okay, so now where I will file a case? Common sense, if there is a defamation case, I want to file a case on someone, he tried to defame me. So then wherever the defendant resides, see, always you will see where the defendant resides, carries on business, or where the cause of action took place. So obviously wherever the defendant resides, we should go in his court and then file, or wherever the cause of action took place. Simple. And that is it. We've completed the entire chapter, including all the past exam questions and the exam questions that will come in your examination. With this, we've completed the entire chapter. Thank you. So we'll do this much. Okay. So this much we'll only do for today's marathon. Do like the video, share it with your friends, and also comment in the chat section what else you need. And tomorrow I will be having another marathon for JIGL, the other chapters as well. Okay, so again I have completed good amount of chapters. The balance chapters I will be covering tomorrow and day after. That is it, guys. Thank you so much. I will see you all tomorrow. And do join the WhatsApp group. The link is given in the description of the video. Take care, guys. Bye.